All right, good morning, everyone. Welcome to our July 8th, 2025 regular Board of Supervisors meeting. As customary, we'll start out with we'll call the meeting to order, obviously, at 9 a.m., and we'll start off with a moment of silence. I know we have one. Did you want to start out?
Yeah, sure. On. Yeah, I'd like to take a moment of silence to remember the lives lost during the major flooding event that took place in Texas over the 4th of July. I'd like to honor the 105 confirmed deaths and hold hope for the 23 individuals that are still missing. May their families and their communities find strength and solace during this difficult time.
I have a couple as well. I'll start off with Ronald Anderson, Robinson Rancheria. He's an elder. He passed about a week and a half ago, and his services were already, they commenced yesterday, and his interment took place yesterday as well. He leaves behind his daughter and his daughter Melinda Anderson, who's a council member for Robinson Rancheria, and her husband Anthony. Grandchildren Anthony Duncan Jr., Nicole Duncan, Jimmy John Duncan, and Peyton Duncan, and so he'll be missed. And we also have Michael Worm of Upper Lake. He passed recently, I want to say on June 30th, 2025, and he leaves behind. Leaves behind his family. I went to school with his sons. He was married twice, and his sons, Mike Jr., Joe, William, Ryan, Randall, Samuel, and Brianna. He always worked hard. He actually worked at Last Mile Auto, if anyone remembers where that was at in Upper Lake at one time. I remember he was a veteran from the Marine Corps. I also remember him from Running Creek Casino. He was a frequent there, and when I used to work there, I'd talk with him a lot. He'll be greatly missed, and memorial services will be held on his birthday, and that would be August 16th this year. So, yep, that's what I have. We offer condolences to those families and the people that you mentioned. Supervisor Owen, could you please lead us in the pledge?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right. Next, we will move on to our consideration of extra items not appearing on the posted agenda. Would we happen to have any?
I have no extra items.
No extra items. All right, we'll move on to consent agenda, which we have right now. We're pulling 5.4 and 5.11 and 5.13 for a future date. Are there any others to be pulled by the board? Anyone from the public?
Morning, Chair, Supervisors. Julia Carrera, Worth Levy Subcommittee Chair. We're requesting that 5.12 be pulled from the consent calendar.
Okay.
Thank you.
All right, 5.12, sir?
I do have 5 minutes, right?
Oh, wait, no, this is just for the consent agenda. Public input will be coming up real shortly. All right. Okay, any other consent agenda items? Not hearing any, we'll bring it back to the board for action.
Mr. Chair, Mr. Chair, I move to approve the consent agenda as proposed with the exceptions of 5.4, 5.11, 5.12, and 5.13.
Second.
So I have a motion and a second. All in favor?
Aye.
Any opposed? That motion carries. So we will now move on to our timed items, which is our 9:02 public input. We're going to go ahead and open it up for the public to speak. Just know that if the item is on the agenda, these items are for, this discussion is for items that aren't currently on the agenda, and if it is something that we can address, we'll go ahead and meet up with you afterward or get you in touch with the director who can take care of that. And you will have 3 minutes, and we will not be able to respond to this as well when it comes to concern. Just wanted to let you know that. And so if you want to state your name for the record, and we'll give you your 3 minutes.
Yeah, my name is Randy Pledger, and I live on Butts Canyon Road, 19455 Butts Canyon Road, and I'm living next to a marijuana grove. I've been living there since the 90s. I'm a Lake County boy. I graduated from Middletown High School. My kids live here. My grandkids live here. Enough of that. Okay. My problem is water. This marijuana grove, about 5 years ago, dug a well at the end of my property. My property is about a quarter of a mile long and it's 150 feet wide. Well, the well is at the far end of it. And he dug this well at the lowest point of the aquifer and drained the aquifer. I have been hauling in water all this time. I have spent close to $20,000 on hauling water. Well, okay, you say, why 5 years and I'm bringing it up now? I've already been to the court and I have won. I have proved to the court that this is wrong. I proved to this court because he did not attend. He came to the first meeting and that was it. I had to run him down to get anything. Okay, I've got my settlement. Why don't I use it? Well, lawyers today want half of it. Well, half of my settlement would get me about a quarter of the way, quarter of the way to the house. I'd have to move the house. Okay. I am very angry. I'm not angry at any of you. You are wonderful people. I am glad to see fresh faces. But I was kind of anxious to get a hold of somebody that I knew so I could relay some of these facts that I have brought up. Originally, I came in here and I told them that this was not going to work because I knew it wasn't going to work. I was there when the surveyor did the survey for the water, and he said at the time that it would drain my well, and I said this was not going to happen. I filed my case then. Okay, this gentleman played scape and evasion for 4 years. The judge had finally got fed up with it, and I had to prove to the judge why I wanted so much money. And it wasn't hard. It wasn't hard at all. Okay, now this gentleman is hauling in water. His pump is still running, so he's still pumping water out of the ground. I have no water. He has got it for his grove, no problem. They're making a bad enemy, this marijuana, because I am an old fart, and I really dig my teeth in, and this is the way it's going to, I'm going to be here. I'm going to be in front of you guys as much as I can. This is not right. I'd like to have some kind of meeting or something with this gentleman in front of you and have him explain to him how water resource had nothing to do with him getting his permit. And I can prove that. It says right there in the permit process that he has to have enough water to not affect the neighbors. I've been affected. I mean, it's cut and dry. But
Sir, if you can wrap up, please.
my time is up.
Yes, 3 minutes. You can wrap it up if you'd like.
Okay, well, thank you. I will be back.
Okay, thank you. Any other public input?
Good morning, Board. For the record, I'm Rachel Dillman Parsons, Social Services Director, and I have a brief update for you and the public today regarding the impact of federal and state budget to Medi-Cal, CalFresh, and IHSS benefits. I'll bring a more detailed update in the coming weeks. As you may have heard, the projections include 17 million people nationwide losing access to Medi-Cal, also known as Partnership Health Plan in California, or in Lake County. Nothing is happening right away to Medi-Cal. The work requirement for Medi-Cal is going to be 80 hours per month. That is effective December 31st, 2026, a year and a half away. And about 42% of people on Medi-Cal already meet the work requirement. A vast majority are going to be exempt. People over 65 and over, anyone who is disabled, and the parent or caretaker of a young child will be exempt from the work requirement. It's anticipated that only 8% of people on Medi-Cal will be required to meet this requirement. However, the cost saving is anticipated based on people simply falling off the program due to the burden of proof. So our department is going to do our best to ensure people are supported in providing that proof. It's going to be super important for people out there receiving Medi-Cal to be responsive to our letters we send them. Please pay attention, ask us questions before your paperwork is due, respond on time, and also be aware that we always give you 10 days advance notice before taking any action to stop or change your benefits. You can always request a fair hearing if you disagree. The information is on the back of the notice. And if you request a fair hearing before the effective date, we pause that negative action and you continue receiving benefits until the hearing is decided. Regarding IHSS, make sure you keep your Medi-Cal active. That is how you access IHSS benefits. There is a new requirement for IHSS that social services must complete 100% of certain IHSS renewals on time. The previous requirement was 90%. The sanction for this has a potential to be $1.2 million per year for our department, so we can no longer afford to be lenient in letting people complete their recertifications for IHSS late. It is very important that the public keep their appointments with us, otherwise benefits will end and reapplication may be required. With regard to CalFresh, federally known as SNAP, in February 2026, there will be a 20-hour per week work requirement. This is called ABOD, able-bodied adults without dependents. We've had this requirement in the past. Social Services is going to launch a CalFresh employment and training program, which the state provides some funding for to assist those on CalFresh in meeting this work requirement. So those are the major federal changes for recipients. For the state budget, Medi-Cal benefits for non-citizens are going to be limited to emergency services only for new applicants if they do not have satisfactory immigration status. As an important note, this has always been federally funded. California expanded. Oh, okay, 2 more sentences. The Medi-Cal asset tests are also coming back. That is effective January 1st, 2026. The limit for individuals is $130,000, and for couples, $195,000. Your home is exempt. A vehicle per adult is exempt. That is all the remarks I have today. I'll bring you a more detailed update. Tara is going to talk about our food assistance partners.
Thank you.
Tough one to follow up. Good morning, board. My name is Tara Gandolfo. I'm the CalFresh Program Manager at the Department of Social Services. I'm here to provide an update on the federal budget impacts on the food banks and free school lunches, as well as the California State renewal of the Sunbucks program. While Lake County Social Services does not oversee these programs, we do work in partnership to address the community hunger, and lessening or loss of the resources in our community will be felt, contributing to food instability and hunger in Lake County. Over $1 billion nationwide has been cut from our food banks and our free lunch school programs. Regarding the food banks, Redwood Empire Food Bank is not Lake County's food bank, but seeing our need, they've been kind enough to schedule multiple distributions in Lake County. Due to funding cuts, they've been forced to cancel some of our Lake County distributions. The most current schedule can be found on their website. I have a food resource list for anybody who'd like to see it. The list is also on our Facebook page, and we update it as we get the information. We're very grateful for all that the Redwood Empire Food Bank continues to do to support our county. Clear Lake Gleaners is Lake County's food bank. Their distributions will continue as scheduled without reduction. Individuals interested in supporting Gleaners in the expansion are encouraged to contact the Gleaners to donate or to volunteer. Regarding school lunches, we are aware that there's news is reporting that the free lunch school program is getting cuts. It's unclear how or when this will impact the county. We've reached out to Lake County Office of Education for more information. In good news, because we like to have something, the California state budget includes Sunbucks funding for 2025. This is the food program that provides families with $40 per month for food in June, July, and August for $120 per child. When they don't have access to school meals. The Sunbucks cards are sent directly to eligible families from the California Department of Social Services. Again, we do not administer the program, so if anybody wants to contact them and has questions, their phone number is 877-328-9677, or you can go to the cdss.ca.gov/sunbucks to get information. Social Services is committed to continuing to partner with our community organizations to address hunger in our community because we don't want anybody to go hungry. Just wanted to share the information with you guys. Sorry it's not great. Have a good day.
Thank you. Any other public input? Anyone on Zoom? No. All right. With that, we'll close public input and move on to our next item, our 6.2, which is our pet of the week.
Good morning, everybody. Hope everybody had a good 4th of July weekend. So I'm Officer Palaio with Lake County Animal Control, one of the officers there. This right here is Sky. He's a husky mix. He's been with us for about a month, and he's about 2 years old, we believe. He's a great dog, a little high energy, but he's good with other dogs as well. We haven't tested him around children yet, but he seems fine so far, just high energy. So he is available for if anybody wants to take him for his forever home. He's a really good dog. He's very obedient. Yeah, but he's great with other dogs. And if you guys have any questions, feel free to come by down to 4949 Hellbush Drive over in Lakeport. Or give us a call at 707-263-0278. Thank you, guys.
Thank you.
Ready to go?
Good luck.
Bye.
All right. Move on to our 6.3, or 904, new and noteworthy at the library. And Mr. Veach is out today, so we will go ahead and pull this, well, not pull this item, but we'll go ahead and just continue on. If there's anything else I got to add, County Council?
No, it'll just be a pulling of the item.
All right, so it's pulled.
Saw 'em in the parades.
6.4, consideration of presentation of Brown Act, and this is County Council's item.
Yes, thank you, Mr. Chair. Good morning, members of the board. We do have a PowerPoint presentation of sorts on this. And I'll just prompt staff to move on to the next slide. And so just as by way of background, my name is Lloyd Gintivano, County Council, and the purpose of this presentation is to just give you a high-level outline of sorts, highlighting some of the more pertinent aspects of the Brown Act for your board and also for the public. The PowerPoint presentation, of course, has been uploaded in the county's Granicus website, I believe, and so it is publicly available for reference, not just for your board, for your board's reference, but also county committees, councils within the county of Lake. So, what is the Brown Act? Well, it's authored by it's named after Ralph Milton Brown, Central Valley Assemblyman. And this was passed in 1953 to safeguard the public's right to access and participate in government meetings within the state. The actual code sections are located in the government code, sections 54950 to 54963. And for purposes of this PowerPoint presentation, I just plan to highlight a few things so that we can move things along. But of course, if any members of your board have any questions, feel free to just raise your hand or flag me. So next slide, please. So the intent of the Brown Act, just to highlight a few of those things, is so that people, the public, members of the public have insisted on remaining informed so that they may retain control over the instruments they have created. And the whole default purpose of this for the Brown Act is to keep, as much as possible, all meetings to be open and public, and all persons shall be permitted to attend any meeting of the legislative body of a local agency. And then there are some exceptions to that, of course, which I will also get into. Next slide, please. Following through with this intent, it's really the whole concept behind this default sort of intent or purpose of the Brown Act is to ensure that the businesses of the local government are conducted on behalf of the public, and that is certainly most certainly the public's business. That's the transparency part of it. Next slide, please. So we get into who is subject to the Brown Act. The Brown Act uses the term legislative body, and that's a term with a specific definition. It includes all governing board of local government agencies, advisory and standing subcommittees created by such governing boards, and all boards, committees, and bodies created by federal or state law. Next slide, please. So then we get into the Brown Act also uses the term meeting or meetings. So it's a very specifically defined term, and a meeting is a majority of the members of a legislative body present at the same time and place to hear, discuss, or deliberate government business. It's also defined as a congregation of a majority of the members, which involves any aspect of that decision-making process that triggers Brown Act requirements. So some of the key terms there for under that definition is a majority of the members. So it would consist of at least a majority of the members. In your board's case, that would be at least 3 out of the 5. There are exceptions to within that definition of what counts as a meeting, and that's what we have there. Some of the exceptions are conferences, trainings, seminars, community forums, and meetings of other government bodies, and social occasions. What I will say, though, under the set of exceptions is a lot of it will hinge in terms of determining what's a meeting or not. A lot of it hinges on the substance of what's being discussed by at least 3 of the board members, right? Again, under that majority definition. So that even if, say, 3 members of a legislative body, the majority of that legislative body, is attending a social occasion, which, would not normally constitute as a meeting. However, if what's being discussed in that social occasion between these 3 members consists of matters that's within the board's purview or within the board's jurisdiction that would normally be discussed in an open meeting, in a meeting, regular meeting subject to the Brown Act, then that is a meeting. So even if it's within an event such as a social occasion type of event. Right. So next slide, please. So in terms of what to avoid, this gets into the electronic forms of media. Again, it references majority of the members may not use telephone, email, fax, internet-based social media platform, or other electronic means or devices, or an intermediary, that's a third person, to discuss, develop a consensus, agreement, or decision. Because again, the intent behind that is to have that be discussed in a regular meeting for the public to see and for public participation. And then next slide, please. And so there are 2 types of meetings, generally speaking, based on how it's defined in the Brown Act. I see that on the 3rd bullet point there. There's a hub and spokes communication where the letters there represent members of the legislative body, where member A discusses a certain topic within the body's purview to member B. A also discusses it to member C, and then A to D. And now you have at least 3 members of the legislative body under that hub and spokes communication that would normally count as a meeting, even if it was discussed by means of email, electronic devices, or just verbally. It would still count as a meeting that would then trigger these Brown Act requirements. The other type of meeting is called a chain or daisy chain communications, where member A would discuss a certain topic with member B, and then member B in turn would discuss that same topic to member C, and so on and so forth until you get at least 3 members who are participating, 3 or more, and that would also count as a meeting. That would also trigger Brown Act noticing public participation requirements. Next slide, please. Also, in terms of what to avoid, polling of the members of a legislative body by another member of that body, either personally or through staff, is prohibited under the Brown Act. However, staff, not the members of the body, but staff can meet individually with the majority of the members if staff does not provide information regarding any other member's views. So that responsibility would fall on to staff to make sure that the hub and spokes is not triggered or does not trigger the Brown Act requirements. Next slide, please. So we get into noticing requirements. There's generally 3 types of meetings, and it's laid out there in the Brown Act, of course, for a regular meeting, much of which applies to regularly to how we post agendas here for our board meetings. 72 hours advance notice is required. For a special meeting, it's 24 hours advance notice, and they get into specifics as to how it's noticed, where it must be posted. But those are the timelines. And then for an emergency meeting, notice must be posted 1 hour in advance, and news media, and certain notices have to go out to news media organizations and other individuals or parties who have requested the advance notice. These emergency meetings typically would apply to natural disaster type of situations where a meeting has to occur right away. Action needs to be taken right as soon as possible, and that's why you have the just 1 hour in advance notice would suffice under an emergency meeting category. Next slide, please. Then we get into just agendizing requirements. The agenda generally would only require, what's only required is that the agenda provide a brief description of every item to be discussed, including closed session, and that gets into specifics as to the type of language to be used in a closed session caption. But the descriptions must be clear enough to be understood by members of the public. Next slide, please. And so the function of the agenda, which is the paper document that's being posted out there and also electronically on the county's website, is a promise made to the public by the legislative body that these are the items that would be discussed in the upcoming meeting. Generally speaking, it's provided in 20 words or less, but again, it must be sufficient to allow the public to determine whether they wish to participate. That's the standard of how much information should be placed in an agenda caption or description item for the agenda item. Next slide, please. And so they're subject to certain exceptions. No action or discussion shall be taken on any item not appearing on the agenda. And here are the exceptions. Members of the legislative body may respond to public input, and we just had that early as part of our regular list of set items. Make reports of activities or announcements. You see that here in our regular meetings, such as our calendar items, right? And your board may also ask staff to report back on a matter at a subsequent meeting or provide direction to staff to place a matter of business on a future agenda. Next slide, please. And I think this one generally refers to extra items, I believe. Additionally, the legislative body may take action on an item not appearing on the posted agenda if there is an emergency or there is a need to take an immediate action which came to the attention of the legislative body after the regular meeting agenda has been posted. So that has been utilized by your board before. Typically, agenda items are posted on or about Friday before the Tuesday regular meeting, as an example. And if something comes, an issue has, if there is an issue that comes up after it was posted, then that would be an option for staff and the board to utilize. As an extra item, bring it up at the Tuesday meeting, goes through the motion requirements in order for your board to take it up, despite the fact that it's not posted. It was not included when that item was not included when the agenda was posted. So next slide, please. So, location of the meetings. Public meetings must be held within the boundaries and the jurisdiction of the government entity. There are a list of exceptions to that, such as the inspections of real and personal property, meetings with federal and state officials, and holding closed session with legal counsel. And the next slide, please. So this one covers the public input and public commenting sections that takes place, that occurs during a meeting. So the members of the public has the right to address the legislative body on both agenda items, which would be public comment, and non-agenda items, such as the one that took place just a few minutes ago, and public input. Those terms are used interchangeably, but essentially one is for the public to make comments on items that are posted in the agenda, and then the other is what usually occurs at the beginning of the meeting, sometime at the beginning of the meeting, where for items that are not posted in the agenda, the public can also comment on those items that are not posted on the agenda. So next slide, please. And I think this one just goes to, again, the general rights of the public, unless subject to a closed session exception to the legislative body, meetings of the legislative body must be open and public, has to have accommodation for disabled persons to ensure access and participation. As far as copies of the agenda packet items, members of the public have the right to obtain copies of all written materials which are distributed to the board, with the exception of privileged materials. And also, members of the public can audio and video record and take photos of the proceedings or broadcast them, unless doing so creates a disturbance. Next section, please. And then next category is closed session. Much like open session items, the closed session item must contain a brief description of the item, and it's laid out specifically. The statutes themselves, the government code sections, lay out suggested language or recommended language of what to put in the closed session description item. Each such item requires a pre-closed session announcement, which is what your board typically does before getting into closed session. Except for those reporting out requirements, strict confidentiality of closed sessions must be preserved. And again, that's outlined in the statute as far as any action to be taken coming out of closed session. It only applies to certain closed session categories. Next slide, please. Thanks. So some of these, there's a whole list of closed session items, and I'll just highlight a few of them that may apply to your board. Personnel matters would be a closed session item, and the appointment, evaluation, discipline, or dismissal of an employee. Labor negotiations are a closed session item, which consists of meeting with local agencies, bargaining representatives to discuss negotiation matters. Next slide, please. Other categories are pending litigation, to meet and confer with me, or legal counsel, my office. Real property negotiations are also a closed session category item. Next slide, please. And then there's also security of public facilities and services. Again, the general intent here is to carve out certain exceptions that would not normally be made open for public participation based on certain policy concerns, such as this category here, which is security of public facilities and services, where involving matters where there's a threat to the security of a public building. Next slide, please. So with all of those requirements of the Brown Act, what are the violations? What's the consequences of that? Well, violations of the Brown Act can lead to an invalidation of an agency's action. So if an action was taken by a legislative body, that same item may need to be taken up again if there is a determination that there was a Brown Act violation in the course of that leads up to that determination or action by the legislative body. Other consequences include payment of a challenger's attorney's fees, civil liability, and criminal liability based on a misdemeanor. Now we get into the teleconferencing requirements under the Brown Act, which I know there's a number, there's a few legislative bills that are in the pipeline. They haven't been adopted yet. So as it stands right now, and my office, of course, will provide updates to those as soon as they come in. But as it stands right now, the teleconferencing under the Brown Act consists of two main types of teleconferencing. Teleconferencing essentially refers to remote appearance, anything other than being in person during an irregular or special or emergency meeting. So the first category is traditional teleconferencing, where generally speaking, agendas must be posted at all teleconference locations. So in a situation where a member of a legislative body wants to appear remotely, the agendas must be posted at that remote location, and each teleconference location must be identified and noticed at agenda and must be made accessible to the public as well. So that's under traditional teleconferencing. Until January 1, 2024, this is under AB 361, legislative body can use teleconferencing without complying with the Brown Act's teleconferencing quorum, meeting notice, and agenda requirements set forth in government code in very specific circumstances. Next slide, please. And these are the specific circumstances. There you have one of which is a proclaimed state of emergency. If there's an imminent risk to the health and safety of attendees, those are pretty narrow items to that this teleconferencing option under AB 361 would apply to, and so it doesn't really come up that often. The next category is a little more flexible, which is under AB 2449. This also exempts the need for certain in-person quorum requirements, but it is also subject to certain conditions. At least a quorum of the members of the body must participate in person. So there must be at least 3 members of a 5-member legislative body that needs to participate in person if any one of the other members wants to participate remotely. Next slide, please. These go into the specific types of audio-visual requirements. There has to be a two-way audio-visual platform or a two-way telephonic service to allow the public to comment when at least one of the body members is appearing remotely. There has to be notice, the means of the public to access the meeting and offer public comment through that two-way audio-visual platform. Next slide, please. The legislative body must identify and include an opportunity for all persons to attend and address the legislative body via this call-in option or call-in feature. And it has to offer the public to comment in real time. Again, this is all within the umbrella of AB 2449 in a situation where at least one board member would want to appear remotely. Those are the specific requirements. Now we get into the basis for or the grounds that would allow for this type of remote appearance by a legislative body member. The standard is just cause. So the board member who's appearing remotely has to provide a general description of the circumstances relating to their need to appear remotely at the given meeting. The provisions cannot be used by any member for more than 2 meetings per calendar year, or, next slide please, or the member requests the legislative body to allow them to participate in the meeting remotely due to emergency circumstances. So we have a just cause category or emergency circumstances in which remote appearance under 2449 would apply. Next slide, please. And then the board, the other members who are appearing in person may decide to allow the member to participate remotely at the earliest opportunity. So there must be action taken by the remaining members who are not appearing remotely to allow the remote member to participate. And then there are these additional requirements on how often can a board member utilize this. Only for a period of more than 3 consecutive months or 20% of the regular meetings for the local agency within a calendar year, or more than 2 meetings if the legislative body meets fewer than 10 times per calendar year. That doesn't apply to your board, that last clause. So now, next slide, yeah, there you go. Just cause, under that, what does that consist of? Well, it's childcare caregiving that requires them to participate remotely. There's a contagious illness category, physical or mental disability, not otherwise accommodated, or travel while on official business of the legislative body or another state or local agency. And next slide, please. I also covered the emergency circumstances, which is generally defined as a physical or family medical emergency that prevents a member from attending in person. I will say that when it comes to the process of providing an explanation or justification by that remote member on why he or she would be appearing remotely, when it comes to whether it's under just cause or emergency circumstances, the suggestion here would not to provide medical information because that is subject to HIPAA. So, because that explanation itself would be provided in the open meeting, in which that member is appearing remotely. So the suggestion there is to provide just a general description of those circumstances that would fit any of those categories, but not necessarily HIPAA-related information or not medical information, not specific medical information. So, oh yes.
Is this the one that's coming up for renew, or they're looking to extend it to 2030?
You know, I'll double check on that. That's the one, what I've laid out is the one that's currently in place.
Yes.
Whether or not, the ones where they're looking to extend it or modify it to a certain extent, that's still in the pipeline through the legislative
Right,
process.
and yeah, we had just signed to
Yeah.
approve it, to recommend it.
Oh, yeah, but as soon.
I'm asking if that's the one.
Yeah, this is the one that's currently
Okay.
in effect, right? And if there are any modifications or updates, is this coming down from, say, the legislature? If it's adopted, my office will certainly provide that up to your board by way of a presentation.
Thank you.
So the last category is Senate Bill 1100, which deals with the disruption of a board meeting and what your board can do. Presiding member of the legislative body conducting a meeting may remove or cause the removal of an individual for disrupting the meeting. There has to be a warning first, though, to that individual that their behavior is disrupting the meeting, and if the individual persists, then that action, the removal action, may be utilized. Next slide, please. So, what is disruption? It's defined as engaging in behavior during a meeting that actually disrupts, disturbs, impedes, or renders infeasible the orderly conduct of a meeting. It includes failure to comply with reasonable and lawful regulations adopted by the legislative body, such as, you know, your board has their own regulations under Chapter 1, policies and procedures of the county as to how meetings are conducted. And also, disruptive behavior also includes behavior that it constitutes use of force or a true threat of force. And I think that's it, unless your board has any questions. That is the end of the presentation.
Supervisor Sabatier?
Thank you for that. I just wanted to, two things. One, we were just talking about the latest meeting rules for teleconferencing. I believe that the sunset clause is January 1st of 2026, so that is upcoming. If there's nothing new, those just go away. If there's no extension, no nothing. Looks like I'm getting a yes, so that's correct. Number two, you mentioned something that I think is, I'm going to slightly disagree with, that it's on staff to know that, but not necessarily, because the liability is on us for Brown Act violations, right? You can't go after a staff member for violating the Brown Act. That is our purview to ensure. So I hope that maybe during a department head meeting, because there's certain department heads that I've had to stop from telling me what other supervisors have told them, that I hope that you can provide such an educational presentation to make sure that everybody, whether they're new or not, it's nice to get a review. It's nice for us to get a review, even though we know what the Brown Act is, just because we fall into traps sometimes of wanting to say more than we should, but the liability is entirely on us to prohibit people from saying certain things when we know that they're starting to tell us how others are feeling about certain things that we're eventually going to vote on. So I just wanted to change that that's not on staff, that's on us, but I think education all around, not just the board, should probably occur.
I had a question. I know that we covered a lot of mainly what has to do with meetings, but there's also some rules, and you'll stop me because it's getting into a couple of things. Whereas the public commonly thinks that, for example, one of us has the oversight over a director and that we can tell that director to do X, Y, and Z, and that's a directive. I don't know if this falls in that purview, if it falls in a different one. I don't, maybe you can help me with that?
So that is allowed because under those circumstances, you have one member speaking to one member of staff, right, or a group of staff over a topic that's normally within the purview of the board. That does not constitute a majority of the board members on its face.
Right.
But certainly, and it relates to Supervisor Sabatier's point, if there is information either coming from staff or the board that lends one to view it as it's not just one board member anymore over the same topic, that's discussing the same topic, it's getting close to, say, a majority of that, then there may need to be a pause there, because normally that would be something that would be agendized, noticed, and then it's set up for board discussion over an item.
I think you might be talking about the policy.
Yeah, and I think that's something we'll be talking about later. But yeah, I'm just getting, yeah, we'll talk about that later. What I'm getting at is one supervisor or two supervisors does not have the ability or cannot tell a director or give them direction or orders or anything like that. But that would be in a later item I think we're talking about.
Correct,
Yes.
correct.
Okay.
That is, yeah.
All right, we'll talk about that another time. I'm just trying to, see if it fits in here at all, so. Did you want to, anybody else?
Supervisor Pyska said exactly what I was going to say.
All right. All right, are there any questions from the public? Anybody online? Yep. Come on up, sir.
Good morning, Board. My name is Tom Lasik. If I may indulge them to maybe go back to the presentation and the first few slides on standing meeting. This is a unique situation that came up in the Board of Supervisors meeting on March 25th. And a member of the public, Betsy Kahn, made a comment about it. I believe it was I'm going to have to look it up here, I apologize. It was a drought water shortage task force. I don't know if you recall that, it was March 25th. And it was decided to create a standing ad hoc committee. A standing committee requires Brown Act, and an ad hoc committee does not. And it was noted as a contradiction. And you can see your standing subcommittees. So I would ask that, I know you can't respond, but I would ask that you take a look at that again, because an ad hoc committee is only supposed to be members of the legislative body and is not subject to the Brown Act. But a standing committee is. And so it's unclear to the public where we actually land on that particular example. So that's what I'd just like to point out, that I want to thank council for putting the presentation together. I've seen it before in other contexts. It's really good. But this is an example of where I think the Brown Act, where the rubber hits the road. And we just want to make sure we're doing it the right way. Thank you.
Thanks. I don't know if you wanted to add anything to that, or?
For that, just generally speaking, we could, staff my office will certainly look into that issue. I've got the name of the committee, so.
Okay, thank you. Any other public comment? I realize I've interchanged the two every now and again. I'll say public input, but that's at the beginning of the meeting, public comment. All right, none on Zoom. If there's none on Zoom, we'll go ahead and close this item, which is a presentation only. And Thank you for that, Lloyd. We'll move on to our 6.5. Public hearing consideration of proposed resolution approving resolutions submitted by Lake County fire agencies and making findings and requesting the County of Lake to implement fire mitigation fees with the automatic inflation pursuant to the Lake County Fire Mitigation Fee Ordinance. CAO?
Is there anyone from the fire districts here? No. I don't have anything to add. It's basically holding a public hearing for the fees that were ratified by the previous fire boards. And they're asking for the board to accept these fees.
Okay, and
That's
then
all
we
I
were-
have. I don't have anything else. I do know there's one item in this list that I believe,
North Shore Fire.
yes, I was going to say North Shore Fire that should not be adopted today or accepted today.
They have to reconduct their mitigation.
I was going to say,
So,
Go
Mr.
ahead,
Chair, if you don't mind, I think that, I just want to make sure people are aware that there is a corrected version of the Lakeport Fire Protection District that was uploaded yesterday. Page 2 was missing with the specific rates as to what would be the increase for Lakeport. So that's on our attachment that was uploaded yesterday. And then North Shore is the only one that utilizes a 2023 increase from the building association. I don't know the exact name of where they're getting the increase from. So they use the 3.777% increase versus what everyone else is using, which is the 1.611. And so I think we need to kick back the North Shore. Everyone else, you can see there's an A and there's an original, and then there's a revised version, and everyone changed theirs to the 1.611. That is the correct version. And so I think that in speaking with County Council, and County Council, please correct me if I'm wrong, the way the resolution that we are approving today or are considering today, there's nothing specific about fire districts in there, individual districts. The only specificity is within Exhibit A. And so my offer is to scratch off North Shore Fire District from Exhibit A. That way we are approving all of the other resolutions that have the correct percent increase and so on. I do want to mention that I think we need to clean up our process. I know in speaking with County Council, there may be a need to address some new findings as we walk through a new process. We're learning things. And so I hope that we can at least get some insight as to what some of those changes might need to be to smooth out the process. And I do also want to make a statement that in our ordinance that we approved on May 21st, 2024 with all of these rate increases, it says that if we do not receive a resolution from the fire districts as of March 31st of that year, in order for rates to be increased as of July 1st, that we shall terminate the collection of these fees. There is no may, there is no, it's up to us. It just literally says we shall, and all of these resolutions are dated May and June. I don't want to terminate today, but I need to call it out that we need to follow the ordinances that we create. And when I say we, I'm talking about between us and the fire districts, because this is a kind of a two-person, two-step dance that we're playing here. But they are obviously not meeting the letter of the law that we all approved and worked with them on. But I also don't want to stop these collections because that would be ridiculous and that only harms our community further. But I think in the review of the ordinance, which again, I'd love to hear from County Council about what needs to be reviewed. I think we need to make sure that we hold everyone accountable to follow the rules that we've set forth, because we're doing that to the members of the public when they come in front of us as well. So those are my comments.
Vice Chair?
I think Supervisor Sabatier may have covered what my question was going to be, but to council, am I understanding it right? This is just a legal requirement that we have based on our ordinance to essentially ratify what they've already approved in their districts.
Generally speaking, yes. So It is done pursuant to the county's own ordinance, which, as Supervisor Sabatier referenced, staff is currently looking into for possible amendments in order for it to address some of the issues that have come up on the lead up to this item that's before your board. But staff is looking into that. But yes, the fire districts, it's all fire district's approval of their resolutions along with your board's approval of the county's resolution. It's all subject to this on the same set of government codes, code sections for fire mitigation fees for this instance, and done pursuant to the ordinance, along with all of the noticing and public hearing requirements that are stated in those statutes.
Okay, thank you.
All right. I'll open it up to the public for comment. Any on Zoom? I'll bring it back to the board. And just to add, each one of these had the same issue, and they all corrected it. We just have to reach out to North Shore Fire to correct theirs. And so, as for that,
I just want to double check publicly with county council, is that an appropriate fix to just scratch that North Shore off of the Exhibit A and the rest of the resolution can carry on?
Yes, so essentially the resolution, by the County of Lakes resolution, would have to be amended when it's offered as amended, with the amendment being on Exhibit A of the County of Lakes resolution, deleting the paragraph that references or designated for North Shore Fire Protection District, deleting that paragraph, and the rest would remain the same.
and then they will come back once it's corrected, right? And we'll have to conduct another resolution.
That's what I anticipate, and that resolution would be just, it's a possible scenario, just going through the statutory requirements. But yes, that resolution would only reference North Shore Fire Protection District, yes.
Okay, thank you. All right.
Mr. Chair, if there is nothing further, I offer the resolution with the amendments as suggested by county council.
Resolution has been offered.
Supervisor Owen,
Aye.
Supervisor Spatier,
Aye.
Supervisor Rasmussen,
Aye.
Supervisor Pyska.
Yes.
And Supervisor Crandall.
Aye. All right. Resolution passes. Let's see, we have, Yep. We are at our 10 o'clock. We'll take a quick break and we'll take, let's see, 5 minutes. Be back at 10:05. All right, welcome back from our break. We're going to move on to our 6.6. 10 a.m. public hearing, sitting concurrently as Clear Lake Keys CSA number 1, number 2, number 6, number 13, number 20, and number 21. Board of Supervisors, Kelseyville County Waterworks District number 3 and Lake County Sanitation District. Board of Directors, consideration of A, resolution confirming collections of annual lighting fees. B, resolution confirming collections of delinquent water fees. C, resolution confirming collections of delinquent water and sewer fees. D, resolution of delinquent sewer fees for the Lake County Sanitation District. And we have Special Districts Administrator Robin Borey and Jesse Salmeron here.
Jesse's back.
Yep, she's back.
So happy to be here.
Okay, so this item, there's multiple resolutions for, as have just been read. They're for our delinquencies in our tax rolls. So Jesse's here with, if you have any questions or if you want to go through each one of them separately.
How does the board feel on that? We'll go through separately? Yep. Go ahead.
The first one is the Kelseyville Water Works, and this is for water and sewer fees, and putting these on the roll for delinquencies.
Okay. Did you want to continue? Do you have any questions, anybody?
No, I just want to say thank you for not putting all the list of people out there. That's an improvement.
That'd be embarrassing.
It was.
Yeah. And there's some people that intentionally go delinquent because they just want it to go on their property tax and pay once a year. So.
Supervisor Spatier?
Yeah, I'll speak to that because it's for all of them. I'm not the complete reverse of what was just said, but I think that if I'm going to approve of putting a tax lien on someone's property. I'm sorry, I wasn't on there. I feel that if we're going to be approving a tax lien, I need to know what the total number is. I need to also have, we don't need names. I think that's not good to have names, but just like any other tax lien that we do, we're looking at what property are we talking about. Things like that, just because there could be some issues. Last time when we had a list, there were some issues in how the list was created. Right now I have absolutely nothing other than I'm giving the green light to go ahead and apply tax lien on properties that I have no idea how many properties, I have no idea what the cost is, I have zero clue other than giving a green light to do something, and I'm uncomfortable with moving forward without further details. And we had paused in the past to get further details. I don't think we should get names, but I've never seen us say yes to a tax lien. For example, code enforcement or others, they don't just tell us some property out there is going to get a tax lien. We have very specific details. So today I cannot move forward unless we have those details, just because I have nothing to confirm that this is appropriate or not.
All right, did you have any comment?
I have a list, right?
So we do have an original list of people who received the delinquent tax notice. So that delinquent tax notice is for people who are 60 days past due of the calendar year 2024. We sent out those tax notices in April. So we have that list that we generated there. Today we asked the board if anyone who's still past 60 days past due on those specific bills, if we could place them on the tax roll. The notice says they have up until July 15th to make a payment in, so it's still a bit of a moving target, but it's on a set fixed bills from the year 2024. So we don't have the total list, but I do have numbers for reference, and I do have the list available. Just for reference. So we made a few adjustments. Last year was the first year that we decided to not have it be a moving target and just be 60 days past due from the tax roll, but instead focus on the calendar year to give them, the customers, more time to pay. So we send those notices out in April. Last year, because we only did the calendar year, it was only 6 months. But the figures have stayed pretty consistent. The year before, in 2023, for the sewer, we rolled about 900,000, and that was in the sewer districts. Last year was about 400,000 because it was half the year. And this year in the sewer tax roll letters, we sent out about 800,000. So there was actually a decrease from the previous years. And all of that is available. We could provide it. We were just, with the whole mishap last year of having all the names available, we thought it'd be better not to bring it.
Supervisor
But it's a
Pyska?
moving list anyway, because so many people are paying their bills, or, if you give us a list today, it would not be the accurate list anyway. So I'm okay with moving forward, giving you the authority to understand who is past due and who meets the criteria.
And just for context, that 800,000 figure, that's what we mailed out in notices. That number is always significantly reduced by the time we do actually roll them.
Right, and if a customer is having issues or needs to work out a plan, they can reach out to you timely and resolve those issues.
All right. Did you want to continue? And I think we can just go through like A, B, C, D. I don't know if we want to go through each and every,
My comment remains
for all.
for all of them.
That's what I figured. All right. Go ahead.
We usually read off each
Yeah.
one since we're doing a.
Go ahead.
The second one is the delinquency for water fees in CSA 2, 6, 13, 20, and 21, which are the water districts around the area. And again, same thing that, they have till July 15th before we actually put them on the roll, and it's only for the ones that were already noticed, not somebody that becomes 60 days past due now. This is for last calendar year. And then we have one for the annual lighting fees for CSA 1. And though all of the lighting fees are already collected on the tax roll, so this is just putting it on the tax roll. And then the sewer delinquencies throughout Lego Sands. That's the fourth one. And again, they have till July 15th to pay those.
And that's all of them?
Yeah.
All right, any questions? Go ahead.
Yeah.
Supervisor Owen.
Actually, Supervisor Sabatier, are you looking for the additional information that you're looking for? Is that addresses, or what exactly are you looking for?
I'm, in my mind, based on practice in other areas, when we have property taxes that are defaulted, we put out a list. Yeah, it's embarrassing, but it's what's owed for the public to get the services that they need. Maybe somebody's not getting their mail. Maybe this is one way that they could know, but right now we're not publishing any information of total amounts or APNs that we are going to tax. And I just think it's the appropriate thing for us to do, to be very transparent about it. And right now, we're being very individualized communication with somebody we may not even be communicating with. And I just, I asked for a list. I did not receive a list. Today, right now, I'm being told there is a list. But I just don't feel comfortable with moving forward without both myself and the public being aware of what it is that we are actually attempting to do. And same thing with the tax default list. That's not the actual list that will be sold. People still have the chance to pay off their property taxes in order not to have it sold. But here, I would treat it the same. And that's
So
just
you're
my-
basically asking for APN numbers and mounts that are not being provided. Okay, I can see that.
Jesse, is that the list you have right there anyhow? It's not the names, it's the APN numbers and the amounts?
It has everything on
This is the internal one, so this has account numbers, owners' names, owner addresses, parcel numbers, site addresses, and whole breakdown of what's past due. This is a really detailed one. We wouldn't provide this to anyone but the owner. But it can be reduced to show the information that could be public.
Supervisor Pyska?
Yeah, and it's not a tax sale. It's just getting what's owed put on the property tax bill so it can be paid. These people know that they have been receiving services and not making payments. This happens annually. This is a way for us to collect what's owed and shut the books for the year. So I think we need to move forward with this.
All right, any other comments? Anyone from the public here to speak on this item, public comment? Any on Zoom? All right, I'll bring it back to the board for action. Lloyd, real quick on these. What do we need a 4/5 or just?
I think it's just majority. I
Okay.
did look into that briefly as during the discussion. I didn't see any 4/5 requirement. And when your board is ready, I could walk through, because your board is sitting in as different bodies labeled as such. Based on each resolution, with your board's permission, I could walk through each of the resolutions for a vote or.
Yes, I was gonna see if there's any other comments first. If not, yes, so walk us through it.
So for the first one, it would be, they're all resolutions, so,
Right.
so just offering them. But for the first one, sitting in as the Board of Supervisors, the offering, the resolution to be offered would be the resolution confirming collection of annual lighting fees in County Service Area Number 1.
Offer the resolution.
Resolution has been offered.
Supervisor Owen,
Aye.
Sabatier,
Abstain.
Rasmussen,
Aye.
Iska,
Yes.
and Crandall.
Yes. Resolution passes.
Then the next one would be also sitting in as the Board of Supervisors. The resolution to be offered is the resolution confirming collection of delinquent water fees in county service areas, CSA numbers 2, 6, 13, 20, and 21.
I offer the resolution.
Resolution has been offered.
Supervisor Owen,
Nay.
Sabatier,
Abstain.
Rasmussen,
Aye.
Iska,
Yes.
Crandall.
Yes. Resolution passes. 311.
Then the next one would be sitting in as the Board of Directors of Kelseyville County Waterworks District Number 3. The resolution to be offered is the resolution confirming collection of delinquent charges for services rendered in Kelseyville County Waterworks District Number 3.
I offer the resolution.
Resolution has been offered.
Supervisor Owen,
Nay.
Sabatier,
Abstain.
Rasmussen,
Aye.
Iska,
Yes.
Crandall.
Yes. Resolution passes. 311.
And the last one would be sitting in as the Board of Directors of the Lake County Sanitation District. The resolution to be offered is the resolution confirming collection of delinquent sewer fees in Lake County Sanitation District.
I offer the resolution.
Resolution has been offered.
Supervisor Owen,
Nay.
Sabatier,
Abstain.
Rasmussen,
Aye.
Iska,
Yes.
Crandall.
Yes. Resolution passes. 311. And we're good. Thank you. All right. Thank you.
Thank you.
We'll move on to our, wait, no, we still have time.
Thank you, Robin.
CAO Parker, would you recommend any?
Yes, thank you, Chair. You may wish to take up 7.3. We have several members of Behavioral Health Department here.
All right, so we'll go on to item 7.3. There we go. All right. 7.3, consideration of amendment number 2 to the agreement between County of Lake and California Mental Health Services Authority, CalMHSA, semi-statewide enterprise health record program in the amount of $1,528,816.56. All right.
Good morning, Board. Amber Luch, Fiscal Manager for Behavioral Health.
All right. You have the
So-
floor, Amber.
We are bringing back the Second Amendment to our EHR, which is our electronic health record. This is the combination of two different amendments. In the instance of them issuing the Second Amendment, they issued a Third Amendment to add AMA licensing fees, which gives us the ability to use CPT codes, which are copyrighted. That's how we bill to the state. So rather than do two separate amendments, we combined the two. So Amendment 2 originally increased the contract by $47,222.56. And then Amendment 3 added the additional $22,000 for the AMA fees, resulting in the total maximum funding of $1,528,816.56.
All right. Any questions?
Seeing Todd Metcalf's name takes you down memory lane a little bit.
All right, public comment, any public comment? I'll open it up to the public. None on Zoom? Bring it back to the board for action.
Mr. Chair, I'll move to approve amendment number 2 to the agreement between the County of Lake and California Mental Health Services Authority, Cal MHSA, semi-statewide enterprise health record program in the amount of $1,528,816.56 and authorize the board chair to sign.
Second.
I have a motion and a second. All in favor?
Aye.
Aye.
Any opposed? That motion carries 5-0-0.
Do you wish to take up 7.4?
Yes. To move on to 7.4, consideration of presentation on Lake County Behavioral Health Services, Mental Health Services Act, annual update for fiscal year 25-26, and approval of modifications to the three-year plan spanning 2023 to 2024, 24 to 25, and 25 to 26, and B, resolution adopting the annual fiscal year 25-26 update to the three-year Lake County Mental Health Services Act program and expenditure plan. And we have Scott and Amber.
Morning. My name is Scott Abbott. I am the program manager for the Mental Health Services Act and Housing. I have a presentation that if I could be upgraded to panel member.
All right.
I don't remember which button to push for the presentation. Okay. Good.
There you go.
Sorry about the delay there. As you probably are aware, or at least remember, we have what is called Mental Health Services Act, and that is oversees mental health services for the last 15 years or so. And part of that is every year we do either a 3-year plan or an update to that 3-year plan. And this is the last year of the last 3-year plan that I need to present to you for your approval. Okay, I don't like it when it does that, but okay. Just real quick, this is a slideshow that's a briefer version of the one that's in your packet. The one in your packet is kind of long. I apologize for that, but this is much shorter. So I'm going to try and get through as quickly as possible for the sake of time. But essentially, we'll be looking at what exactly the Mental Health Services Act is as a refresher. We'll talk about the community planning process that was done for the last 6 months for this update. And the results of that, and the modifications to the current 3-year plan. And then I'd just like to spend a little bit of time talking about the Behavioral Health Services Act, which is from Proposition 1 last year that has significantly altered the Mental Health Services Act. and it will be impacting our community in coming years. And also just have a little bit of data just from behavioral health that I'd like to share. Excuse me. Mental Health Services Act. Is it, just real quick, it's an act that, like I said, was approved by Proposition 63 in 2004. It represents a 1% tax on anyone that's making over $1 million. And that is distributed to the counties based on their population size. And there are specific components and requirements to go within that act. One of the main ones is the slide before you, which kind of is the breakdown of the funding that is supposed to take place. 76% of that funding is for community services and supports, and about half of that funding is for this full service partnership program, which is probably our most significant program that we have in the mental health department, which is designed for those who are most in need due to their mental health and are at a risk of either incarceration, institutionalization, or homelessness due to their mental health. It also funds other programs such as our peer support centers, and then we also have prevention and early education, which is another 19%, and then innovation, which is 5%. The last two, workforce education and training, and capital facilities and technological needs, both of those actually come from the top ones, CSS, where we have the option to be able to divert 20% of our CSS funding for those two categories. Purpose of the annual update, as I mentioned earlier, by law, we have to do an update of each year. MHSA is a very grassroots-driven process. The proposition was very grassroots and that it started, and it's the idea that the community has the input on what services are to be provided and what are the priorities are for services for MHSA. Hence the community planning process, which goes into that. Just real quickly, there's also contained in the update is a PEI evaluation reporting, which is just a requirement. They want the state as required a separate report just for prevention, early education processes and programs that have been happening in our county. So that is also a part of it. MHSA background overview. It can also be found for further information on our website at this particular web address. This slide right here just represents the programming that we have that's based on from our MHSA funding. Just real quickly, I won't go through all of them, but our crisis access continuum includes being able to support our mobile crisis services that we are doing. I mentioned our full service partnership, which I mentioned is probably our largest program. Also trauma focused co-occurring disorder screening and treatment. Our peer support recovery centers, which is also a very, very big program that we have, as you are probably familiar with the 4 different peer support centers we have around the lake, the Big Oak Center, Lavos, Just drawing a blank here.
Circle of Native Minds.
Circle of Native Minds, and Harbor on the Main. Also, we have just within our prevention early education programs, we do a lot of outreach within the schools, doing presentations, doing mental health first aid, suicide prevention, doing a vast amount of that. Our goal is to be able to give every 10th grader in the county mental health first aid, so that they can be able to recognize mental health issues. And it also helps kind of reduce the stigma that goes along with mental health issues. Innovation reports, we currently do not have innovation project at the moment. And CAF Facilities and Techniques has gone to our electronic health record. And we do have some funding set aside to update our South Shore Clear Lake Clinic. Just real quick here, this is demographic or kind of display of how many folks we are serving within MHSA and their makeup. So for the CSS programs, 586. For the PEI programs, because we're going out, like I said, touching schools, doing events and other things like that, we end up touching a lot more folks. The CSS programs are more of the treatment-centered type of approaches.
Supervisor Spatier?
Can I pause you on back one? So I've had a recent discussion with behavioral health about this, and I just kind of wanted to highlight this. And it's one that I've noticed in some other reporting for the race ethnicity, 48% or 46% unreported or unknown. I would like to see that number decreased to understand who exactly we are serving, knowing that when we do our community health needs assessment, which includes behavioral health to a certain degree, we recognize that certain groups are much more lower on the status of health and mental health. And it's hard for me to continue to understand if we are serving the easiest to serve or the neediest that need to be served. I know that there's efforts being made, but it's all very anecdotal and rhetorical rather than shown through the data. And so if there's ways to use the INN dollars that right now is not being funded or does not have a project in order to make greater attempts to capture that data, that would be greatly appreciated, because there's times where I feel flying a little bit blind as to exactly who it is that we are serving. I know we're serving, but I don't know who it is that we are serving. Just wanted to mention that.
Yeah, I appreciate that. Often when the data is collected, it's collected from the clients themselves, and many of them do not report, what their makeup is. They just choose not to. But it's something also that we recognize that we need to do better at. Probably innovation dollars aren't necessary for that. I think it's just just more increased effort to do that.
Supervisor
I mean, that was my point too, is that's self-reported. So it's difficult to force people to report. We can't. But having more welcoming environments, a place that feels more safe, we work on that, then maybe people will feel more compelled to report something other than unknown.
I totally agree. And we'll talk, there's a little bit more the same data at the end of this presentation. The slide I just showed was this mostly MHSA. Also the slide just entirely behavioral health, which gives a little bit more information. I do want to report on a little bit of outcomes. These are the outcomes for our full service partnership program, which I mentioned is our largest program. And these next 3 slides show that, you know, that this program really makes a difference in people's lives. And this one shows that due to the full service partnership program, the interventions that it does, it increases the number of partners living in traditional residential settings and reduces the number of partners in emergency shelters, psychiatric hospitals, and long-term care. So that's one of the main goals, is to get people in recovery, being able to live in the community, as opposed to being incarcerated or institutionalized or homeless. This next particular one shows emergency events, which essentially are trips to the emergency room. That Full Service Partnership has also reduced those for the folks that are in the program. And this last slide shows the number of arrests that have been reduced. There wasn't a lot arrested to begin with in this, but it did go from 3 to 0. As I mentioned, the community assessment, we did that for the first 6 months of this update, and I want to go through the findings of that community assessment. The data was gathered mostly in two different ways. One from a community survey that we did right at the beginning of the year. We got 49 respondents, and then we did 2 community meetings at the end of January and the end of March. And you know, from that we got both qualitative and quantitative data. So some of the findings that we got from that, perceptions about Lake County Behavioral Services meeting the community's needs were mixed. Respondents generally felt that peer support services, which are the peer support centers, meet the needs of the community they serve, while prevention and early intervention services do not. And I suspect that for that last one, about the prevention and early intervention services, that many people aren't aware of the prevention and early intervention services that exist. For example, going into all the different schools. So that kind of tells me a little bit more. We need to kind of get the word out of what we're doing to the community. Access to services. Most participants knew how to access behavioral health services. However, participants generally felt it was not easy to get an appointment. And so this is an area that we are addressing as an entire department to improve. Experience with services have been positive perceptions, feeling that we are helping. Here are some strengths that were identified for the department as a whole through this survey. Welcoming, approachable, available, that we do some outreach, we're responsive, and again, the effective peer model, which people seem to greatly appreciate. Some identified gaps that the community assessment survey found is suicide prevention. Felt that there needs to be more done. Substance use, follow-up support. For example, when people do graduate or from programs, having some follow-up support with that. Services for mild to moderate needs, and again, prevention, as I mentioned. These are the folks that are felt we could do better at. Young children and teens, older adults, unhoused individuals, historically marginalized groups, which would include minority groups such as the Native American community or LGBTQ. So this provides some opportunities. We have we identified that, ways our department can do better. And so all these are kind of ingrained within the different programs that I described earlier. And so, the results of this survey are being used to improve within each of the programs, as opposed to, creating new programs or altering programs or anything. These will be integrated within existing programs to improve quality. Again, here's a listing of different services that we have or provided by MHSA. And because this is the last year of a 3-year plan, and the next year BHSA starts with a whole new set of conditions, we didn't want to make a lot of modifications for this last year of this plan, as we're going to be starting new stuff, brand new stuff, next year. And so, as far as programming. And so, one thing we're looking at doing is folding in the trauma-focused co-occurring disorder and screening treatment program, folding that into the full service partnership program, because essentially that's exactly what's happening right now anyway. We're not having a lot of responses as the trauma-focused program occurring just independently, but it has been existing within other programs, and so we want to emphasize it within our full service partnership program. The other change is innovation, where we have an opportunity from, and I'll talk about that in a minute, but we got an opportunity from Cal MHSA for them to create a dashboard. We call it dashboard program. I don't know.
Dashboard.
Dashboards for our EHR. To be able to quickly and more efficiently read the data that exists within electronic records, health records. And this is exactly just what it has said, sorry. And again, this is kind of reflects what I talked about here, of the modifications that we'll be making kind of within our programs to address some of the findings that were in our surveying and meeting data that we collected. Some of these things we've already implemented. For example, enhancing our presence on social media. We have Megan, who is here, and she is our social media guru. We try and get all of our announcements and so forth on social media. I don't want to go through all these just for sake of time, but this is the idea of what we've learned from the community assessment of integrating it within existing services. I don't know if anyone has any questions about this.
No,
I think it's kind of self-explanatory, but let me know.
You can continue on.
This is the fiscal part. I kind of want to emphasize this a little bit because just for transparency of how MHSA works. As I mentioned, it's a 1% tax on anything made over $1 million. The funding is distributed to all 58 counties based on population size. Due to the 1% tax, just the nature of it, funding kind of ebbs and flows. Sometimes there'll be a lot, sometimes there won't be, depending on how the economy is doing. And so as you can, the estimated statewide MHSA funding in that category, you can see that it does vary by around $1 billion for the state. And so that affects the funding that we receive. We receive I think it's like 0.18% of the funding due to our population size. And so from that, you can see we kind of estimate for 25, 26, and 26, 27 based on statewide revenues that they're expecting, what we should be expecting. Now, the good thing about MHSA, something that I've greatly appreciated, is because of the kind of volatility of the funding, we do have 5 years to spend any given year. And so that allows for carryover funding. And so, because of that, we can be a little more even in our approach as far as funding and spending. Because we have 5 years to spend an amount of money, we can kind of,
One second. If we're having conversations, if we could step out. We're almost finished with this presentation. I know we're behind a little bit, but I hear a lot of talking, and I think it's been distracting some of the other folks. So go ahead and continue, please.
Sure. Anyway, so we can spend more kind of in the middle. With the carryover on lean years and excess on not lean years. So this is our overall budget, which includes unspent funds carrying over into these categories. We never spend $8.4 million, but it's the funding that currently and will exist for MHSA. What this is about is our annual revenue and expense report, which describes where the funding is spent. That's on our webpage, and so if you are curious, or if anyone is curious to see how our funding is spent, this gives a nice description based on breaking it down by CSS, PEI, innovation, and so forth. Any questions on that before I move on? Okay. I just want to, like I said, just quickly touch on the Behavioral Health Services Act. That was part of Proposition 1 last year. I just want to kind of cover this because it's something that we will be bringing back to the board to talk about. So it's kind of a preview of what we'll be starting to work on. Because, again, well, let me just describe the Behavioral Services Act. Behavioral Services Act, what it did is it renames MHSA to BHSA, which means that it expanded to include substance abuse services besides its mental health services. It significantly revises the distribution of funding and prioritize housing, and I'll show you that slide in a minute. It establishes expanded oversight and accountability measures, including an integrated plan for mental health and substance use services. So it's aimed at trying to be more transparent in how the programming works. The other component of it, which I just kind of skipped over, was part of Proposition was Behavioral Health Infrastructure Bond Act. That was the one that raised $6.4 billion in bonds, and some of that funding will be used in Lake County, which is great. This is a slide I really like because it really kind of sums up the differences between MHSA and BHSA as far as funding allocations. The pie chart shows that the state is going to keep an extra 5% in their distribution. And then you can see the current modifications which I previously described of CSS, PEI, and innovation, and so forth, and how that transfers down to the new categories, which are essentially, they're looking at, for BHSA, 35% for FSP. And that's pretty close to what we have right now. We have, right now have as 39%. FSP, a really significant portion of that funding goes for our housing that we pay for, housing assistance, including supportive permanent housing and temporary housing across the county. And so, like I said, that essentially kind of remains the same. What is very different, though, is that PEI, innovation, and everything else has been kind of scrunched down into the 35% of which they call behavioral health services and supports. So and they did that to make room for the other 30% for housing, which as you know, California is looking to address homelessness, and the governor has thought that MHSA would be a good way to do that. But unfortunately, that also would mean the reduction of other services that we currently do, particularly our peer support centers. However, there is an exemption that small counties can apply for populations under 200,000, where that 30% housing intervention is not done for this next 3-year plan. This category is also going to be included for larger counties for the next 3-year plan, but smaller counties can take advantage of it earlier. And so that's something that we will want to consider doing, particularly because we currently address homelessness in our current plans, and our behavioral health department is very, very involved in addressing homelessness right now. And but again, this will have to come from the community. We need to get the community involved to help guide this decision.
Scott, if we can wrap up.
I'm sorry.
We are way behind now. Yeah.
Okay. This is just the hot timeline. Thank you for letting me know. More information is also involved on here. Just real quickly, there's 2 slides worth of data of overall of the folks that we serve. This first one is the penetration rates of how many folks that we serve within the community. And this last one is kind of what we touched on a little bit earlier on the demographics, racial backgrounds of those that we serve. As you can see, threw me off for a second, 78,000. Well, I figured out that meant that was duplicated folks in there as well. So that's why that number is bigger than our 65,000 that we have. Okay, that's it.
All right.
Sorry.
Questions from the board? Supervisor Sabatier?
Can we get a copy of that slide? Because you have other slides that aren't in the one that was
Oh, it's not in the
provided. Yeah,
Yeah,
please.
we can do that.
All right, I'll open it up for public comment. Any on Zoom? No. All right, so I'll bring it back to the board for action.
Mr. Chair, it looks like 2 parts to this. Do it separately.
Yes, so the first part is just a presentation, I believe, unless,
I thought it requested approval of modifications
Yeah.
Yes.
to the 3-year.
so that would be by motion.
Okay. So, Mr. Chair, I'll move to accept the presentation and approve modifications to the Mental Health Services Act Annual Update Plan for fiscal year 25-26.
Second.
So I have a motion and a second. All in favor?
Aye.
Any opposed? That motion carries 500.
And second, I would offer the resolution adopting the annual fiscal year 25-26 update to the 3-year Lake County Mental Health Services Act program and expenditure plan.
Resolution has been offered.
Supervisor Owen,
Aye.
Sabatier,
Aye.
Asmussen,
Aye.
Pyska,
Yes.
and Crandall.
Yes. All right, I think that covers them all. Thank you very much.
Thank
for
you
the
very much.
presentation. All right, we'll get back to our timed items here. We are on our 6.7, consideration of a presentation by Sonoma Clean Power on a feasibility study for Sonoma Clean Power Lake County expansion. If you're here on this, present on this item, please come up and please join us at the table.
Oh, there.
That's the internet.
Okay, yeah, I cannot see.
You could just go to the top bar. That works too. There we go. Good morning, Board. Ben Rickelman, Deputy County Administrative Officer, here with Sonoma Clean Power. As you're aware, on April 15th, 2025, your board gave direction to staff to request that Sonoma Clean Power update their study on the feasibility of extending an offer of service to Lake County. That presentation included discussion of Sonoma Clean Power's services and their GeoZone initiative. Subsequently, Sonoma Clean Power's board directed staff to conduct a feasibility study of Sonoma Clean Power's expansion to unincorporated Lake County, the city of Clear Lake, and the city of Lakeport. Lake County has periodically considered community choice aggregation in response to Ordinance 3026, which your predecessor board adopted June 23rd, 2015, authorizing implementation of community choice aggregation with the goal of reducing energy costs. The feasibility study, the updated feasibility study found significant savings, potential savings for Lake County residents. However, that cannot be guaranteed for potential regulatory changes and changes in the energy market. Jeff Cyphers and staff from Sonoma Clean Power are here to present their feasibility study, answer any questions from your board, and provide further information on potential next steps.
Thank you, and good morning, Board. I'm joined, Jeff Cyphers, and I'm joined by Ryan Tracy, our Director of Planning and Analytics, and then a few members of our team, Miles Horton there, Ashlyn Rogers, who's a new intern, Claudia Sisamfu, who's our Tribal Liaison and Public Relations Manager, and also Erica Torgerson, our Director of Customer Service, are here with us today in case there's any tough questions I can't answer. Our board sends greetings to you. They are interested in exploring this opportunity with you. And in June, they did vote to begin a process where they can go back to their home cities and counties and discuss this matter with an intention of offering an opportunity to Lake County in August for joining. And so that's one of the things that's before you. And for those who are here who are new to this topic, I will go over a few basics. And I think it really begins with creating an option for your constituents to benefit from using the clean geothermal power you already generate in your region. That's one, I think, that I've heard. Steering California's aggressive outlook at building new geothermal energy in ways that benefit your county and your region, and adding new customer support and rebates on top of what PG&E provides today. And I'd add to that, fighting for lower rates is a theme that I've heard desired here, and we share it. So I think today we do have a detailed presentation. Feel free to interrupt at any time. I do have a slide to reserve time at the end for questions, but I understand you're running a little behind, so I'll do my best to catch you up. So the overview of Sonoma Clean Power really begins with just talking about what community choice is. So CCAs were invented by the legislature back following PG&E's first bankruptcy and really the Enron crisis as a way to interject local governments into the energy markets to have better oversight and better management to try and reduce the risk of another energy crisis. And today, that model has proven so successful that there are now 25 operating around California. We're serving a majority, us and our sister agencies are serving a majority of PG&E's customers at this point, and it's rapidly growing in Southern California as well. What we do is really generation. It's not the poles and wires, it's not the substations, it's not the billing. And what that means is we've replaced PG&E's power sources with our own. And what we try to do when we do that, and we can usually succeed, is cut emissions and cut rates more than half the time. And we'll get to how that works. But one thing I really want to emphasize for those who are new is that we do not replace PG&E. And so PG&E still manages all the billing, all the operations of what we call the grid today. And what we're really doing is introducing a choice. So customers today have one power producer, and that's PG&E. And what we do is we help introduce a question of who do you want to generate your electricity. And so by default, SCP becomes the public power provider when we serve a territory. And individual customers can still choose, do they want to opt out of our service and go back to PG&E, or do they want to stay with us as SCP? So it does introduce that choice that customers don't have today. Just to kind of emphasize that with a graphic, we do the generation, we run the power plants, PG&E does the delivery. So they do the wires and the billing, and we consolidate that billing process. So we began our service in 2014 in Sonoma County, and then just a few years later expanded to Mendocino. And we're organized as a public agency, so it's local governments, and we generate the power for almost all the customers in those two counties. 13% have opted out and chosen PG&E as their generation provider, and the reasons for those opt-outs vary. Some is a distrust of government, some is a dislike for the fact that we're default providers, and some opted out and then came back. And so we've actually recovered a number of customers in the years since. We are completely self-funded. We cannot use tax dollars. We are a separate entity from the counties and the cities we serve. And I'll get into that funding piece in a bit because that matters, and it's one of the things I really invite you to explore closely. The purposes of what we're up to is really, I mentioned improving oversight, cutting rates when we can, and pollution, but also investing locally and helping customers with improving customer service. And so I'll give you some examples of that. So a quick fun tour. We build large things. This is a wind turbine out in Livermore, California, and we've constructed 46 megawatts out there. And that is a typical project and scale of things that we work on. We also do really small things. This is in Petaluma, California, on the Lavio Ranch. That was a dairy farm that was struggling, and they leased their land to us to put a megawatt of solar on it. So we do work at both ends of that scale. We work with the local nonprofits, and this is just an example of one of the programs we have is to provide financial support for nonprofits to get electric vehicles for their services, and that helps them lower their maintenance costs and their fuel costs. And so that's usually the first price of an electric vehicle is the big hurdle. So we do that kind of thing. And we do a lot of work in schools and trades and academies. We really want to make sure the workforce is getting enough training for the next generation. And so we've got a lot of grant programs and partnerships. We are in classrooms with over 17,000 children every year already doing our programs. And we would love to think about that kind of opportunity in Lake if that resonates. So what has happened since we last met a couple months ago is that our board directed us to complete a feasibility study. Ryan Tracy led that effort. And the feasibility study is quite detailed, and I think it's included in the packet, yes. And what we found in that study is that we didn't see cost increases for our existing customers across Sonoma and Mendocino County, and that was one of the things we really needed to check, is that over the long run, would there be a cost increase for our existing customers? And we found that it did not. And we also found that the most likely scenarios, and certainly with all the data that we had in May, we found total bill savings for customers under most market conditions and a majority of situations. The update box on the right is something I want to flag. And so just 12 days ago, the CPUC voted a decision that will delay credits that PG&E owes back to our customers by up to 4 years. And the import of that is that we're effectively having to ask our customers to loan PG&E's other customers an interest-free loan for up to 4 years. We've protested that. We don't think that's good practice to have customers loaning money to other customers. But that decision is something that we've gotten used to over the years, over the last decade. Rules change very frequently in this market, and the PUC has a habit of changing rules that are fairly significant every 6 to 12 months. And so this will create more volatility over prior to this decision. What it will tend to do is make bad years worse and good years better. So it will tend to take the results of the feasibility study and shrink the savings for the next 2 years, but increase it for years in later years. And that's a frustration. We don't like volatility. But one of the things I want to convey is that this is part and parcel to doing work at the California Public Utilities Commission. We have this kind of regulatory change that goes on pretty frequently. So I want, in full transparency, to just let you know that affects the results of the feasibility study. It doesn't affect our conclusion of the direction and the probability that savings will occur more than half the time, we believe, under all the scenarios we can see. And so I'll unpack that further in later slides. So our board did vote in June to start that 60-day process with an intention to make a formal offer at its August meeting. And one thing that the board did clarify is that even though that vote to join Sonoma Clean Power is different than a vote to join our geozone effort, our geothermal effort, our board did ask us to really confirm that we have good, strong alignment on the desire to construct new geothermal resources that are beneficial to our region. So that means low water, lower seismic risk, located outside of the geothermal setback zone, things like that. So basically our wish list for geothermal energy. And I think the importance of that is that having that strong alignment, as I hear from my board, if we don't find that alignment, we should all pause and think about it, because Sonoma Clean Power is 3 years into this effort and very committed to constructing new geothermal in Sonoma and Mendocino counties. And so I think that might be a good checkpoint to have a deeper conversation if we find, as we go through this, that we don't have that alignment. A couple more presentations coming next week in your 2 incorporated cities. And then I want to get into how we operate. So we are organized as a joint powers authority, and our participants are the cities of Sonoma and Mendocino counties and those 2 counties. And then we also have two cities that have long-standing municipal power enterprises. So that's Healdsburg and Ukiah. So today our board consists of 11 members, and each of those directors are appointed by their agencies. So if this board joined, then this board would appoint a member to sit on our board. We have a staff of about 55 people, and we're headquartered in Santa Rosa, California. The key roles of the board are really on budget, setting rates, hiring and reviewing my performance, and approving all of the policies and plans that govern how we transact, what we build, where we build it, what types of resources, how rapidly, how aggressive we're focused on rates versus clean power. All of those strategic decisions are really done through our planning process that our board authorizes. And then any non-energy contracts above the spending authority. Energy contracts are very tightly controlled through policies the board sets, but because those transactions sometimes have to occur on an hourly basis, on a phone call, those policies are what govern with legal oversight, and then those energy contracts are reported after the fact to the board. So I want to talk about the importance of a joint powers authority. So almost all of California's CCAs are JPAs, and the reason for that, and the handful that aren't, are city enterprises. So City of San Francisco and City of San Jose are not JPAs, but the other CCAs are. And the really important thing there is there's a financial firewall in California law that says if local governments form a joint power authority, then our assets and our liabilities of that JPA are not the assets or liabilities of its members. And so that cuts both ways. The good thing is our liabilities would not be yours. And that's really, really important because on an average year, we might have $1 to $2.5 billion of contract liabilities. So the scale of power is really gigantic because we're buying a lot of it on 20-year contracts. So it's a long, long commitment. The other side, though, is that we can't really provide funds to your general fund or to meeting other county and city needs. So it is a clear firewall in that regard. The benefits we can provide are through our services, not through our funds. And so the JPA sets up that structure. The purposes that were outlined in our governing document is really around cutting emissions, competitive costs, and in years since that was written, cheaper when we can was sort of added on to that sentence. Helping customers cut their bills. So we do provide a lot of services, both through phone, through web, and through walk-ins, and through community events on how to trim your power bill. It might be oriented around the summer or the winter when bills tend to change. It might be oriented around some equipment we're mailing out. We have a box right now we're mailing out with a lot of equipment to cut your home energy bill. And so that is a key function that we serve. We also do have a goal of investing locally. And to date, that has been as simple as donations to scholarships and nonprofits, to fire relief funds. It has been more sophisticated in recent years where we are buying property with the purpose of building energy resources ourselves and owning and operating them instead of only doing that by contract. That will likely increase in years to come for two reasons. One is we have the capacity to do that now that we're 11 years old. But the other reason is with the elimination of many tax credits of the federal government, private companies no longer have a price advantage for building renewable energy. And in fact, probably public power enterprises have a financial advantage because we have a lower cost of funding. So doing our own development is a key goal. And we've recently stood up a department whose exclusive purpose is that work. And then of course, promoting long-term rate stability, energy security, reliability, and resilience. We too have a lot of power outages. We have regions that have more than 20 days a year. of outage, which is really bad. And so we're used to that issue. And I know I've seen the diesel gen set behind this building. I know that you likely do too. So we share that. I want to say a little more about default service because I went through that pretty quick in an earlier slide. So when agencies like ours form, the law does require that we become the default provider to all customers. And we can't deny a group of customers service because we don't like that customer type. And that was set up to prevent cherry picking so that these agencies couldn't go around and just say, I only want to serve the big industrial customers because they're more lucrative, and then leave all the homeowners behind. So we do have to be the default. And I want to remind that individual customers, whether residential or commercial, can opt out. And so they can choose, they can go back to PG&E for power generation. The process is that each customer will receive, this is all presuming this goes forward, of course. Each customer will receive 5 notices in the mail over a 5-month period. And during that window of time, we don't have any fee to opt out. If customers wait and opt out later and go back to PG&E, we do charge a $5 administrative fee to homeowners and renters. And we also charge a $20 fee for commercial customers. So we do have a charge for that. And so one thing that we do during that 5-month period is make sure we're out in the community, we're running radio and print and social media, we're making sure people are aware of this. We don't want to charge fees, and we don't make money by doing that. It's more a matter of trying to get everyone who wants to opt out early on and make sure they're happy, they're with the provider they want. So the experience, and this is presuming action this year in terms of offering service from our board in August and then accepting that at some point later this year here. What customers would then experience is that throughout the middle of next year, we would be out doing community presentations all around the county, getting ideas from you and your staff on where it's high value to meet a lot of customers and to make sure they're aware of what's coming. And then the process for enrollment and launching service would begin in the spring of 2027. So we'd be mailing those notices, and then service would begin throughout the month of May. And this is the soonest that we can do this because the CPUC has sort of a 1-year waiting period after all the decisions have been made and plans have been filed and certified. They still have this 1-year window where we have to commit to serving but not begin. And so we have that kind of fairly long timeline. So the billing process is, power bills are ridiculously complicated, so I don't want to defend power bills in California. But one thing that California got right is that we've consolidated billing. So customers, when there's a CCA like Sonoma Clean Power, they still only get one power bill. And you'll see in the middle of that chart that there's a delivery charge for PG&E, and then there's a generation charge for Sonoma Clean Power. And there's 2 separate numbers. And sometimes customers say, why am I paying another entity for generation? And so there's a question. We get a lot of phone calls about that. And so the quick answer is we're replacing PG&E's generation charges, with our generation charges. So we basically took away their generation charge and added ours. And so that consolidated bill is really important because otherwise they'd be having to pay 2 bills, and that would be very confusing for a regular customer. So I want to highlight some of the benefits and risks and make sure that that I receive any questions that you guys have on this front too. This is an important topic. And I want to begin by talking about some of the benefits. So the new option for a power provider that individual customers get, the investments into local energy resources that we're winding up and expect to scale over the next decade in significant ways. The funding for local public benefits and nonprofits and scholarships. We have a pretty far-ranging educational program that starts in elementary school and goes all the way through the trades and colleges, junior colleges, and we're really proud of that. Cutting emissions, air pollution and emissions, I think that's a key goal that we can deliver on very quickly. This next one about being an advocate at the California Public Utilities Commission in Sacramento, we could gloss over that, but I want to pause for a second because the last bullet point's about lower rates when possible. Over the last decade, we've cut power costs a little over $100 million across the whole decade for 2 counties. That's a big number, and it's great, and I'm really proud of it. And through advocacy, we've cut power bills more than double that. Over $200 million of errors we found in things like rate cases at PG&E that when we fixed them caused double the savings. So I don't want to gloss over advocacy. It's the biggest financial benefit we can provide because it's only every 3 or 4 years we catch some big error, but it can be a doozy of an error. And so I think that's something that I want to keep emphasizing that matters. So I did show this back in May, but I want to show it again. The history of total electric bills in our territory over the last 11 years. We've usually been cheaper. About 80% of the time, we help provide savings. So if the bar is below the line, it means that being an SCP customer helps save money. I also want to note, none of those percentages are gigantic. We're not saving anyone's household budget because of our existence. The best savings we've had is about 7%, and that was in 2024, and we've managed to sustain numbers very close to that throughout 2025. And I'm really proud of that. 7% off your electric bill is not like a billboard ad. It'd be way better if we could say 30% or 50%. But I'm proud of it because 7% costs us about $50 million. So just to get 7% savings, we have to have $50 million lower in electric generation costs in a year for our current territory. So it's a big effort to get to that. But that red circle matters to me. We cannot promise lower rates, and we can just promise we'll fight for that. That's our mission.
I have a question.
Yeah. Let me see. Can I back up? Ooh, I don't know how to back up. Okay.
So Jeff, in the feasibility analysis, you kind of talked more explicitly what happens when PG&E rates are lower. Can you just mention that really quickly, and then I'll ask my question, kind of what happens when PG&E rates are lower and what that does to Sonoma Clean Power rates?
Yeah. So we don't chase PG&E's rates up and down. We do try to smooth things out for customers, and it's really important that customers don't pay rates, they pay bills. And I know that's like an abstraction, but what I mean is customers pay the bottom line. And the bottom line includes PG&E's charges, includes any CPUC fees, it includes our charges, and so it's a bundled package. And so what we're trying to do is smooth out and lower their total bill whenever we can. So if we know, here's an example of something that maybe isn't intuitive. If we know PG&E is going to increase rates dramatically next year, and we're already lower, we might increase rates a little bit this year, bank up some reserves, and then cut our charges next year to smooth that out. So customers have less rate shock, right? So kind of a balancing account approach. When PG&E is substantially cheaper than us, which happened in 2021, our total bills were 5% above, which we didn't like. And that is a situation where we were concerned that customers would opt out and go back to PG&E. And by and large, we found that customers didn't. They were still interested in getting the support that we had, in the rebates that we had, in the services. And so I was surprised by that. And that was including low-income customers and rural customers. And so we think there's a little bit of grace. I don't want to test that any more than we have to, but that is something that did happen.
Okay, so I went to Patty Poppy's Roadshow, and I know Miles was there, and had a conversation with her also offline, talking about the future of PG&E rates, and she's insistent that that the generation rates are going down, the delivery rates are going up. And so I'm just wondering what that would look like for our constituents, knowing that that's happening, and how you're planning for that, and actually if it ends up happening as they sort of try to utilize the benefits of the duck curve that she likes to talk about.
Yeah. So we do expect, based on the current forecast, that PG&E's generation costs will go down next year relative to this year. And we've been planning for that for a decade. And so one thing that we've done is we've built up a rate stabilization fund. And by the end of this calendar year, we should have about $100 million in that. And that the purpose of that fund is to subsidize rates, to remain competitive with PG&E and give that money back to customers, basically. And so that's one tool that we've got in our kit. I don't want to sugarcoat it that when PG&E's rates drop dramatically, like, we do have to dig deep and look at our funds. The trend is not in that direction. So even though their CEO is saying rates are going to go down, I expect that will be true next year. I don't expect that's the long-term trend. The long-term trend of power costs in California has been growth faster than inflation.
Okay. So, but they are projecting lower rates over the next 10 years. What she said. But
Yeah. Okay.
That's what they're projecting.
Yeah. That story also came out a week before they had a big rate hike. So,
Yeah,
And that was so curious, because I asked her about that, and
Yeah.
she was very insistent. Okay. So I just wanted to bring that up.
there's great people at PG&E.
Yes, there are, and
I don't
we
count
do
her
have a good
among them,
relationship.
sorry.
Right.
Supervisor Spatier.
Yeah, I was just gonna say, words are words, actions are actions. We'll see what the bills actually say, because I listened to an interview with her about how it's gonna stay stagnant for the next 3 years. And then here comes the news flash of new rate increase coming to the CPUC. So I'm gonna call a spade, and your bill's gonna keep increasing at least over the next 5 years. Maybe not today, but tomorrow, yes.
With a roller coaster of ups and downs, I'm sure. Briefly, California's annual power sources last year, primarily natural gas, hydro, and nuclear. Solar has taken an enormous bite out of burning fossil fuels in California, but of course solar only runs when the sun's shining. And so California's resources still have a ways to go on reaching really true clean power status. We'd love to see that geothermal segment of the pie grow, and one of the reasons we want to see the geothermal segment grow is it also eliminates the need for natural gas too. And so it does two things at the same time. You don't have to pay natural gas to sit around and wait for that winter night when the wind's not blowing and the sun's not shining, and then fire up in that time. You can actually deliver the power from renewable energy all the time. This is in comparison. So last year, our power sources, our default mix, we had 18% geothermal. We had significant solar, although not matching California's utility resources. And one reason for that is we have over 200 megawatts of customer-owned solar on rooftops in our territory. And so us building a lot of central solar has less value to us than building everything else, because our customers have already done a really good job of building solar. And I haven't done an assessment of Lake County yet, but I would bet that you're in a similar situation where rooftop solar is an important resource around here. On the right is our optional premium service, which is mostly geothermal, all local, and solar power. And what that resource is called, we call it Evergreen, and it is a premium. It adds about $25 a household per month. $13. That's better. $13-ish per month, depending on your usage, to the price tag. So that's not for everyone. But what it does is it shifts all your power resources to resources that are in our territory. So 100% local, 100% 24-hour. We're the first power provider in California to ever offer 24-hour renewables. This is every hour of the year. And I'm really proud of this. It doesn't just showcase the value of the geysers. It also has been an impetus for investing in local solar and batteries and local resources. And so that's something we want to see grow. That is still a modest number of customers today. Sorry.
Go ahead.
Well, this is very exciting because all we've ever wanted is to have our local power sources be utilized by our residents. So obviously that's something that we really, really want. If and when there are other power sources developed in the county, do our residents get a lower rate, or do we benefit at all from that, or is it just kind of go into the whole portfolio?
We haven't tried to have special carve-outs for individual projects or individual jurisdictions, in part because that makes things really complicated and it also raises fairness questions. But we have made a major effort to look at the package of resources we're building, especially locally, and make sure that they're benefiting financially and from an environmental standpoint all the customers in the region. So one of the things about geothermal that's such a boon is that we're seeing, and I'll get to a couple slides, we're seeing a lot of new technologies worldwide that are expanding where you can do this and what it costs. And so actually, if I may, or do you
Well,
want
I
to
just have
finish?
one other question, because you were talking about rooftop solar.
Yeah.
And so many people are locked into the plan of when they installed that rooftop solar, and some are more advantageous than others. And so if the customer is with Sonoma Clean Power, do they have a different plan with Sonoma Clean Power? And then if they were to opt out, would they go back and lose that original plan with PG&E?
So they do. We do have a different way of crediting customers that's slightly different than PG&E. But a rooftop solar customer still pays PG&E's delivery costs on power flows. And so the amount of benefit that we can provide to a rooftop solar customer is pretty small compared to what we can do through our advocacy or just through general rates. And so it's not, I don't want to overstate the case that solar customers with us are way better off than with PG&E. And if we want to get into some detail, I can ask Erica Torgerson to add some detail. So if you want to go deep, we can go deep.
To answer the one question, though, I think you're asking Supervisor on the whole grandfathering, the SCP switch does not reset a grandfathering date or get you, lose your grandfather status or put you on a different trajectory.
Okay, so but just like, we don't have to go deep on rooftop solar, but is it comparable? Someone has a plan right now, and we switch over, is it going to be comparable?
I think Ryan put his finger on the key thing, which is the net metering crediting system you're under does not change because of our service.
Okay.
So you stay with whatever you have. There are some recent rules that make it so if you sell your home and move, the new person coming in won't get the same benefit that you got. So, but that's not due to us.
Okay.
Yeah.
Supervisor's about to you.
I just wanted to make sure that there was an answer to that important question, and thank you for making sure there was an answer to that.
Thanks. So speaking of geothermal, one of the things that I think is really important to highlight is that geothermal power has come up again and again as a method of supporting our solar industry, our wind industry, lowering long-term energy costs because of its capacity to keep the lights on all year round. And if folks haven't been tracking the amount of dollars that Northern California folks like us have been paying to Southern California natural gas-fired power plants is increasing, even though we're burning less fuel. And it's increasing because they have to fully staff those plants, they have to keep them fully maintained, they have to keep them on standby, and some of them are operating for a few hundred hours a year, or maybe a couple thousand hours a year. And so they're not really recouping very much cost through their sales. So their price per unit of sale has just gone through the roof. And so one of the things that we've really identified is using some of that new geothermal technology is going to be, over the next decade to 2 decades, is going to be really important for lowering energy costs and improving our outcomes. Not to mention jobs, tax revenues, et cetera. So I think one thing for background is that California has already ordered construction of 2,000 megawatts of new geothermal power across the state. That is something that didn't exist a few years ago. That is a new order, and so that is likely to produce a fairly significant pressure on all of our regions, Sonoma, Mendocino, and Lake County, as well as the Salton Sea area in Southern California, to get into the permitting process and approve projects. And so this connects back to our geozone effort, where a big part of our focus isn't just championing geothermal, it's also steering the geothermal in ways that's locally beneficial. So getting community meetings together, getting town halls, making sure we're demanding to understand what is the fluid you're using to drill, disclose that, et cetera, all the things that the public's going to want to know about that process. And so because they're such an important partner for Lake County, I just want to acknowledge we have an ongoing dialogue with Calpine about potential partnerships. And but significantly, we're spending a lot of our effort looking outside of the geysers footprint and looking at new locations across our two counties today where geothermal would make sense, using technologies like enhanced geothermal systems, EGS, and advanced closed loop. And these are technologies that allow us to use much less water and to drill in rock formations that don't require the geysers type of volcanic formation. So that opportunity zone today is really in southeastern Mendocino County and northeastern Sonoma. And our goal is to construct 600 megawatts of new clean power. We've created our first pass at community criteria for that. And I would look to expand that should Lake County be a part of it. I think the opportunity there I wanted to show, this is obviously a very rough map. If Lake County were to join SCP and the GeoZone, the early interest area that we've identified would be mostly probably outside of that geysers, the geysers being that small yellow figure in the 3-county area, but also mostly in the southern part of Lake County. That appears to be where EGS and advanced closed loop have the most potential for expansion. And we have reviewed the geothermal setback area, and we've met with a number of neighbors around here years ago and to learn about experiences of geothermal in your communities. And that was part of informing our policies for Sonoma and Mendocino County. But we've gotten a start at hearing community concerns and interest. And obviously, if there was service, that would expand very significantly. We'd want to make sure we're dialed into everything that you want to talk about and make sure it gets addressed. And the setback area is clearly established, and we would want to honor that. The last significant section I have, I've got two. I've got a process and a risks. I want to highlight two pretty significant risks of joining SCP. And this is part of this not being a hard sell. We want this to be a mutually beneficial thing and come back as often as we need to answer all your questions. But the very long-term commitment of this is something to consider very carefully. Because we sign a majority of our power supply on a long-term basis, and this is 10 to 20 years in length in contracts, in order to finance the construction of those projects, that does mean that even though individual customers can leave and opt out, the county itself couldn't force all your citizens out of the program without making sure there's no cost obligation left behind for the remaining ratepayers. And the JPA spells out the terms, but the really key terms are you'd either need to provide very long-term notice, which could be as long as the longest contract, so that could be 20 years, or pay the costs of the power supply contracts to make sure customers don't have rate increases. That second option we don't think is very tenable because the dollar figures could be enormous. Certainly in the tens of millions, could be in the hundreds of millions of cost obligations. And so I think one of the really core considerations of joining any CCA or starting your own is that you're really stepping into a process that should be thought of as a very, very long-term game. Like building a sewage treatment plant. You're not building it to operate for 10 years. You're doing this for 50 to 100 years plus. The other one that I want to hit on just a little more specifically is the fact that we can't guarantee lower total bills. And just to underline that it is likely that at least some of the time customers will have higher, it says rates, but what I mean is total bills. And the reason we can't promise that is, Ben kicked this off, is changes in regulation are frequent. They occur seemingly annually or more often. PG&E's own fees on our customers can change pretty significantly. So there's a fee that protects PG&E from having any above market costs that get stranded. And what that means is they bought power supply contracts on behalf of all their customers years and years ago. We took some of their power generation customers away from them. And if their contracts, if they can't liquidate those contracts in the market and recoup all their costs, then our customers owe them the difference. And that fee can vary over $100 million from year to year. It's a very volatile fee. And so we make forecasts of that fee all the time. PG&E itself makes forecasts of that fee. And we plan for it by having significant cash reserves and trying to be nimble. The last thing is that energy markets themselves, for any energy, for example, back in 2022, I think you were part of that extreme heat wave, and we had an extra $8 million of cost that month because it was so much hotter than our forecast that there were extra costs. And so I want to emphasize the fact that we can't have a guarantee is due to things that are outside of our control. So we can definitely control our reserves. We can definitely control our conservative nature, but we can't control PG&E or the PUC. We try, but we don't get to.
Supervisor Pyska and then Supervisor O.
I appreciate you bringing up the risks. They are significant and they need consideration. And I'm hoping during this time, we don't have to do it today, that we can have council review so that we can thoroughly vet all of the risks and then come back to the board so that we have a very clear understanding as to our constituents.
Absolutely. And I encourage that. I think a fully informed process with everyone is the only way to do this.
1 second, do we have one more?
We had actually received a comment and their risk factors, the amount of the risk factors, that would be the millions that you're talking about opting out early, 40 million, whatever it is, 100 million. That would go to the county if they opted out early? Is that correct? Or because you had then mentioned ratepayers and not putting, and obviously that can't happen.
Let me step through this. So if Lake County joins SCP, you are now a member of this JPA and get a seat on the board. All of your own municipal accounts, electric accounts, would default over to Sonoma Clean Power for power generation, as well as all of the citizens in unincorporated Lake County. So all of the businesses. So all those accounts would default over. Any one of those entities, including the county itself, can opt out of our service and go back to PG&E. That's their election, and they can do that almost at any time. They can opt out, go back to PG&E. When you go back to PG&E, you must stay there for 1 year. PG&E captures you for 1 year before you can come back. We don't have that 1 year obligation, but they do. And so individual customers can make those choices. What I was trying to say is the county and the incorporated cities can't force your citizens out of the program prematurely without this extremely long noticing period, or the cash that is not really a very viable option. And so, did that clarify that?
So the county would be responsible if we opted out, if the county decided to cut it?
If you forced your residents and businesses out of the program, then you would be responsible for that cash consideration.
That's what,
If we forced them, or if there was a percentage Because I seen there was a percentage as well. The
So
percentage
it-
doesn't,
I think
Are you getting this?
what Jeff's talking about is if the county decided to leave Sonoma Clean Power.
Yes.
In its entirety. The individual opt-outs, and even like Jeff was saying, even if the county's electric meters, if you're just opting those out, that's not relevant to this discussion of liability. The liability is if this board made the decision, we don't want to be in Sonoma Clean Power anymore.
Correct. Correct.
and
Okay.
that's before the 20 to 25 years, if we opted out before that?
Yes, so if you said we want a cost-free option or ability to leave, you could give notice to us. We would then look at what's the shortest time period where we could help you get out cost-free. And then the number could be as large as 20 years. It might be less, but it could be that long. That's the disclosure.
So to clarify, we would opt in for a minimum of X amount of years, up to 20. So we'll just use 20 as a round figure. So when we signed up with you, it would say a 20-year minimum? Or would it be, if we decided to opt out 5 years down the road, we would start the 20 years at that point? That's what
It's the second,
second,
not the first. So joining this kind of agency, I really encourage you to think of it as a permanent decision. It will outlive us all.
Sure.
And so it's not so much signing up for a 20-year period, it's signing up for a continuing commitment. And the reason for that is those long-term cost obligations. If you then later, or a later board, made a decision to exit out of SCP, to Ryan's point, then that's when the timeline starts
Okay.
for that process.
Because I was unclear on that. Now, something else you had said when you were explaining the first part of my question, you had said that if we signed up, we would come on, the county would come on, and you mentioned the businesses, all of the businesses. So they've automatically, we have opted them in? The board has opted them in automatically? Or do they need to one by one opt in?
So it's automatic, and that's state law. So the purpose of that really is to prevent us from cherry picking like the most favorable customers. So we have to be the default generation provider for all the customers.
Okay, because that was really unclear earlier when you were
Sorry about
here a couple months ago.
Okay.
I thought that each person opted in. I didn't realize that they would have to actually opt out, that we, as a board, sign them into it.
Yes. And so that is one of the purposes of having a pretty significant community engagement effort before any of this happens. And so my expectation is that we'd have 20-ish events in 2026, and then probably at least 10 during 2027 during the enrollment period, plus a lot of media and social media and so forth. I think the awareness of people, it takes more than one time to get somebody's attention about something like this. So we've done a good job. Our history is that we get very few opt-outs after the enrollment period. People who want to leave generally pretty early, and because we're good at getting that message out. But it is a reality that you are making that decision.
Okay.
Yeah.
So that all the county, the businesses are all opted in automatically. What about the residents?
Yes,
They
everyone.
opt- Everybody, the entire county opts in. Okay, that was unclear to me to begin with. One other thing that I was unclear on from when you came, I think it was in March, versus today, that seems a little ambiguous, is when I talked to you in the past, we'd mentioned, I thought you were producing the power. And now it looks more as though you are purchasing the power from, say, Calpine or other entities, rather than producing it.
Yeah, so CCAs start by contracting with third parties for power, same way PG&E does. So PG&E in the 90s had to sell off almost all their power plants. So when they go out to generate power, they have to contract with merchants like Calpine and others. And so we use that same process to generate our power. Historically, that's been cost favorable for us because of federal tax credits on renewables, and we couldn't monetize those tax credits in the same way a private company could. So we were saving customers money by contracting out, I don't think the next decade's going to look the same. I think it's going to look different. And so we've been standing up our efforts, our bonding capacity. We've issued our first bond for just shy of $1 billion to refinance contracts. We've been standing up our capital projects division to construct resources. And that's not going to happen overnight. We're not going to be building giant projects in one day. But over the next decade, that is the goal, is to build and own and operate more and more resources and look more like a municipal power enterprise than a CCA today. Yeah.
Okay, thank you.
Vice Chair?
Yeah, just to clarify, but I think you said there'll be a time after they're automatically opted in if we did this. There'll be a period of time where they can opt back to PG&E without this $5 or $20 fee. How long was that period of time?
A 5-month period with no $5 fee. Yeah.
Okay, thank you.
Yeah. And we would take the prior year to get that message out too. It's just that people don't have time to listen until it's real. And so it'll be a much bigger push during the enrollment period in terms of getting folks' attention.
Thank you.
So I think my last prepared section is on process, and then I'm happy to continue the discussion. So the timeline, should all this feel like it's good to go in the next few months to the rest of this year, would be to engage with council, with staff, with yourselves individually as need be, on really kicking the tires, understanding the legal risks, all the issues, understanding the JPA itself. I'm happy to make our counsel available to yours anytime you need them. And then on August 7th, I will be asking, as long as this resonates with this board, I will be asking our board to at least extend an offer to Lake County so that you can consider that. And then later this year, we would be interested in coming back and testing whether you're ready to pass an ordinance and a resolution. And so the ordinance would satisfy the state obligation, and then the resolution would be joining SCP and abiding by the terms of our JPA. And then we would file an updated plan with the California Public Utilities Commission late this year, and then that would look for service in mid-May of 2027. So that timeline. So just kind of more graphically, the feasibility study is completed. Our board started their own review period of 60 days back in June. And then looking for our board to send an invitation for you to consider in August, and then starting service in May. So just a different depiction of that. I want to pause there because that was a lot, and I know you've got time, so I'd love to turn it over to you, Chair.
What is your role with power safety shutoffs?
So PG&E controls when they occur, including the fast trip system, the EPSS system, and so we don't control them. What we do, however, is look for opportunities to make them less frequent. And once in a while, we can find an opportunity to have a small segment undergrounded or some other technique. And I want to give Ryan Tracy credit. He found one of those examples in our service territory today. And we successfully got PG&E to underground a quarter-mile section, and they stopped shutting off power to a whole giant section of our community. And so we have that kind of slower response effort of planning. And then we also do work with customers with extremely frequent outages on trying to figure out backup power systems or help them plan for more complex solutions like microgrids. We don't currently build microgrids, but we are connected with a lot of the folks who do, and also have enough know-how in-house to help people navigate the early phases of planning for that kind of a system.
All right. You were next, go ahead, and then Supervisors Sabatier, go ahead.
So in the feasibility analysis, but not in the presentation, you talked a lot about customer support. And you likely won't have an office here in the county, but.
That's an open question.
Okay.
I absolutely know that we need a presence here.
Yes.
And so what that looks like is unclear. And so I think one of the things we're navigating right now is testing how we're doing in Mendocino with different efforts, with regular office hours, with frequent events that are known, with communicating through supervisors and other electeds in that region, and through like frequent regular kinds of communication, like at scholarship events and things like that. And what we're learning there is there's different techniques that are paying off more than others and that customers are appreciating more than others. I'd love to do the same thing here and just try out 5 or 6 things and see what works best. I wouldn't want to commit today to an office specifically. I'm not sure it would get utilized as much as I would like, but I can absolutely commit that if this goes forward, that we would try out a number of things and see what works.
Okay, good. Because we do have a good relationship with PG&E in that sense. They're, they're very supportive of us individually and our constituents. They visit our town halls. They do have a large presence. So I want to make sure that we would build on that and it would be, if not equal, then better to what we already have. For major outages and disasters, we've had fires. In my district, we have a lot of winter outages with snowstorms. And so I want to talk to you about your role in those events and, well, your experience. You have some, I know you do. Mm-hmm. And how our customers would be supported and how our board would be supported in those types of events and you know, re-energizing communities. And along with that, we have warming shelters that are set up in my district when we have heavy snowstorms and I have a lot of people out of power and they need to go there for resources, and PG&E usually stands those up. So I want to make sure, again, that I don't have a lapse in that service for my constituents when they need it the most.
That's super. So actually our first disaster experience was the Valley Fire here in Lake County. We were only operating for a year, and our board chose to make it was admittedly a small cash donation. We didn't have a lot back then. But that was our first experience with it. Obviously with the Tubbs Fire and other mega events in our region, we had a lot of experience. Following the Tubbs Fire, one of the things that I'm really proud of about CCAs in general and SCP specifically is we can respond very quickly in a planning and service mode. We are not a first responder at all. We support the second responders, so the nonprofits who go in and protect streams, the folks who do warming centers, all those things we can make donations to. We can send support staffs at some times when we have the capacity. And following the Tubbs Fire, one thing we did is we stood up a rebuild effort where we partnered with PG&E, and this was a really good partnership where we went in, we counseled families who'd lost homes on how to rebuild, how to make insurance claims, how to get through the permitting process. We gave them up to $17,500 to do it energy efficiently with solar power and so forth. And that was a very successful program. And it ended up getting copied in the campfire, following the campfire in Paradise, and also copied in Malibu in Southern California because it was a good model. And so that's an example of something that we can do. But I want to be clear, we're not first responders. So it's PG&E and 911 that you call when there's a disaster. We really have more of the slower planning role in terms of helping avoid the next disaster or supporting the responders.
So because in those events, it's the infrastructure that's damaged, so then does PG&E continue with the CRCs?
Yes. So PG&E has no change in how they respond to distribution upgrades, to disasters, to operations, to OES coordination and all the rest. That stays the same. And we've seen that again and again. PG&E performs really well at that kind of work, and I'm really proud of them for that. When I'm critical of PG&E, it's mostly their upper management and their decisions around strategy. It's not their operations. So I have a lot of respect for them.
Okay, thank you.
Supervisor Sabatier.
Thank you. Thank you for coming back and doing the feasibility study. And I believe in the feasibility study has said that about 15% of our homes have rooftop solar, just for an idea and concept of where we stand at least.
great.
I don't know how that compares. Very interested, but also very concerned. I'm mostly interested because I'm already concerned, because PG&E is just something we should all be concerned about. But I'm trying to figure out, like, I want to go with the long-term commitment here. What is your vision of where electricity will be in 20 years? Because where we are today in comparison to where we were 10 years ago, let alone 20 years ago, is vastly different, where people have a great ability of disconnecting if they want to, if they have the means to purchase batteries and solar and other things. I'm nervous about getting in a long-term commitment where you're in a long-term commitment with something that becomes absolutely antiquated, and we're stuck with something that we don't really want to be connected to because of the changes that are happening technologically. Batteries are getting smaller, batteries are able to store more, batteries are getting more affordable, all of those things. So just where do you anticipate technology to move? And I guess I'm asking a dumb question that you wouldn't tell me something just so I can say, no, I'm not interested in doing that. But I just feel like we're talking about technology that is in existence from yesterday that we finally put to use today, that we're talking about expanding versus really looking forward and what do communities look like and how do we energize communities 20 years from now rather than committing to something that exists today.
The exciting thing, so first of all, we don't know what it's going to look like in 20 years. I'll be really candid. Whether data centers reignite California's interest in nuclear power is an open question. California currently says no new nuclear power. Whether hydrogen takes off, open question. Whether carbon capture becomes significant and viable and cost effective, open question. There's a lot of things that are out there that we don't know. I think what is exciting to me is we already have all those sunk costs now with PG&E, and we don't believe we're adding to them. We actually think we're trimming some costs along the way and creating jobs in the process. And so for me, the opportunity for Lake to consider is help us figure out what you want invested in. That's what Mendocino and Sonoma do today, is they tell us, we're extremely interested in these types of technologies and also customer support. Just in the last 5 years, our board has shifted gears. We were all about building renewables mainly in the first few years. And now our board's really, really focused on cutting energy use and really helping customers trim like winter heating, electricity and cutting costs by doing that. And so we've had to build out facilities and services to help customers do that more meaningfully. I think having a seat at the table in that question is really kind of the goal of a CCA. And to me, that's why I'm here, is I get to make guesses about the future, but then pivot along the way and be able to adapt to new things that come along. I was not laser focused on anything but purchasing existing geysers geothermal until Ryan showed up and said, here's the economic potential to actually close other power plants that we're not using very well if we build more geothermal. And I hadn't seen that. And so there's new information that comes along all the time. So I'll be candid.
And I appreciate that. I'll go on to, I know we have a lot of resources. I know we can look very attractive to specific agencies that are looking to tap into those resources. I don't think that those resources should necessarily be completely off limits, but at the same time, I know you talked about the setbacks and so on and so forth, but there's other impacts that occur outside of just the physical setbacks. My personal opinion is geothermal might be deemed green, but there are potential issues that come along with that, and we shouldn't ignore those issues, and we shouldn't hide them under the rug either. So I think we need to figure out a way to move forward, but we need to benefit from those ways and also make sure that there's not a detriment to at least the surrounding communities. I know we showed some pictures of some new plants. Again, there didn't seem to be anything for almost miles away from those plants, or at least the pictures that we saw, there was nothing else other than just those power plants. And I don't want to create deserts here where we can't build anything else as we develop and grow into the future. You mentioned in your feasibility study that we're probably one of the few. I know Mendocino and Sonoma have natural gas where we don't have natural gas. Correct me if I'm wrong, but I believe there are winter and summer rates for PG&E where they kind of decrease the cost of natural gas and increase the cost of electricity depending on the use. Well, we deal with that even though we don't have natural gas, which is absurd because we shouldn't be paying more for something that we're still using. But how does that impact your ability to provide when we're so much needier during the winter months? I know that was kind of captured in the feasibility study, but I was hoping you could talk a little bit more about that because we seem to be slightly different than the rest of the communities you're currently serving.
Yeah, I'm going to ask Ryan because Ryan spent a lot of time thinking about that topic, and so I want to ask Ryan.
Yeah, no, I think that was actually a key concern going into the feasibility study. You know, knowing that that Lake County has a winter load that we would have to serve that is out of proportion compared to what we normally deal with in our current territory, which requires a more sophisticated, diverse set of resources. You know, as opposed to where summer we're really geared towards solar and batteries. We got to look at geothermal and wind. So that was a big part of looking at when we take Lake's load and fold it into the Sonoma Clean Power portfolio. Can we meet that load cost effectively? I think the findings of the feasibility study is that we are able to do that and able to actually see some benefit because we might be having to procure more expensive resources to meet Lake, but it has other benefits to the rest of our portfolio by spreading that out over a larger base and some other counteracting features that make it work.
Thank you. And then currently, are you able to provide all the power that Lake needs, or do you need to contract out in order to obtain the power you need to provide the power for Lake?
Yeah, so Lake, we're actually in a very good position because one of the hardest requirements to meet in our portfolio is the PUC requires us to have a certain percentage of our portfolio in renewable long-term contracts. Those take a long time to find, projects that are being built and negotiate contracts. We're in a good position where we have an excess of those, and we have a sufficient excess to fold in Lake without requiring any additional procurement. We will have to go buy more power in the spot market, but that's something we're very nimble at being able to do. But we're in a good position.
Hence how bringing in Lake would decrease the potential cost or not increase the cost to your current customers. And so that goes back to what my colleagues were asking, kind of trying to dig a little deeper, where if 50% of the population opts out, it is still feasible to move forward and there is no liability placed on Lake County for saying, yes, we want to be a partner, yes, we want a seat at the table, because of the fact that you didn't create new contracts that now can't meet the need, and automatically everybody has to pay a whole lot more for it. Am I correct that that percentage can be an enormous percentage? You're saying 90%, and I'll get back to that in a minute, that's kind of your expectation.
That is correct.
If it was 50%, there wouldn't be a harm done back to Lake County for not having people wanting to opt in and actually opting out.
So there is no legal or direct financial consequence to that. The indirect financial consequence, in full disclosure, is if enough people opted out everywhere, costs would tend to go up on the remaining customers. We have enough of an open position where we can absorb reasonable and even somewhat surprising opt-outs without causing rates to go up, but it's not unlimited. So there is a potential indirect impact. Because Lake County's population is relatively small compared to our current service territory, 50% here actually is an absorbable impact that would not, in my view, risk any financial harm to the remaining customers, and there would be no direct financial impact to the county.
Okay. And then my last comment is about your the opt-out process, and I know it's state law, so it's not something you're doing, it's something you have to do. The fact that you anticipate 90% to stay opt-in, the fact that you didn't see a whole lot of people dropping out when PG&E had higher rates, the fact that you're getting phone calls saying, why do I have two bills that I'm paying in one, tells me that ignorance is bliss in the sense for you guys that people don't know because there's so many things happening around us that you have to pay attention to. Obviously, there's enough people that don't understand that they're even maybe signed up with you because they're still paying their PG&E bill. You may be trying your hardest to advertise and do outreach, but my gut tells me the majority of people probably just don't know, and when the bills are actually higher than what PG&E would be, they probably don't know that either. And so that's a concern I have of kind of putting some shade over that, in the sense that I wish there was better visibility on the bill to say, here's what you would be, kind of like when you go to a savings store, you go to grocery outlet, you just save this much compared to going to a normal grocery store. Sorry, not a normal grocery outlet, you're normal. But you know what I mean, like there's not anything that mentions what your savings are because, or you would have paid less if you were a PG&E. So I feel there's a level of ignorance that comes along with the program that makes me slightly uncomfortable. But again, interested, concerned, want to continue the conversation and figure out where we should be. Tough decision for a 20-year, because again, I anticipate lots of changes in what's going to be available, and I think it's going to be more and more localized rather than centralized as far as where we get our energy. Actually, one last comment. Can you help us, if we wanted to become like Healdsburg and Ukiah, where we can run our own municipal utility district, but still getting generated electricity from you guys? Would that be, is that something you've ever looked into? Is that something we can do? Just want to put that out there, because I would love to see us having more local control over how we power our local entities.
You're not alone in that desire. We hear that from a number of tribes, we hear that from a number of smaller communities, and we hear it from some of our cities and counties. And the simple answer is that creating a municipal utility in California today is nothing like it was 80 years ago. It was pretty straightforward to do 80 years ago. Today, the laws are written to protect the investor-owned utilities. And so San Francisco's been trying to municipalize for something like 30 years, and they haven't finished the job yet. Yolo County's been looking at it pretty seriously for probably a decade, and they're not done. And so that is a difficult undertaking because it is a hostile takeover. It is not done politely. And so I don't want to pretend like there's a clear path to that. What I do know is if you're in a power enterprise like a CCA, which is the easy step to take, relatively speaking, compared to municipalization, and you build the relationships and the resources, and you have the trucks and the trades going out and servicing resources, it becomes a credible alternative. So if PG&E really screws up big in the future, then, and the governor agrees and the legislature goes along with it, having the ability to municipalize becomes a plausible act. I don't think it's that plausible if we don't have all those services up and running. And so I do think it's an insurance program, but there's no clear path to immunity. There's no obvious path.
Thank you.
Go ahead, Supervisor Owen.
I too am excited about it. One of the things that we had talked about back when I met with you at Calpine was the closed loop system, which was pretty exciting because it takes quite a lot less water to run it. You don't lose as much. I know that many years ago when the geothermal geysers were first getting going, at one point Lake County was kind of difficult to, made it difficult for them to build in this region, in this area. And we've lost a lot of the income. A lot of the income is now in the Sonoma County areas because we don't have those. The first plants that were built here now, I believe, are closed down, such as Ford Flat and Bear Canyon. So we're not reaping the benefits. Much of the steam is going, our steam is kind of being taken out into Sonoma County, and they're reaping the benefits. So that was one of the things that I had spoke with you about, if you were interested in putting in something so for the tax revenue for the county in our area. And that was kind of the area I was leaning in when I thought that you guys were actually producing the power. That's something I would actually be interested in, so that we had a revenue. There's also, I don't know what the pulse of the people are, and with everybody opting in, that's something I wasn't aware of until now. I didn't understand that. Would you be interested in attending town halls around the county, at all of our town halls, and kind of letting people know, and so that we could gauge what people are wanting and what they think about it before, because right now I'm, on the fence, to be honest.
Yeah, I'll take that, of course. And I think one of the things that does is it probably makes a 2027 service date look like 2028, and that's fine.
That's fine.
I just want to full disclosure, like it probably does add some time to that process. But
absolutely.
Yeah,
But I think it's worth it because we need to know where the community, because we're speaking for them. And we need to know what they're thinking, and, they're going to have concerns that I haven't thought of. So, yeah.
And then on the geothermal piece, so yeah, we are not the producer, but I think what the GeoZone introduces is we have a much more hands-on relationship with these projects than CCAs have had in the past. And I think one of the big benefits is it brings in the ability for local jurisdictions, communities to kind of have a voice in thinking about early project decisions, bringing the types of technologies and people to the table, and figuring out what the hurdles are to get stuff built. I think before, when we started our relationship with building, we were still getting resources built. The power contracts we were talking about, the pictures of the wind facility that Jeff showed. That project was built because Sonoma Clean Power signed a PPA. Even though we weren't necessarily the people putting the steel in the ground, we were the people making it happen. So we're still using that playbook for a lot of the resources we're building, but with the GeoZone, we're having a much more hands-on, proactive approach to thinking about addressing barriers and also steering things in directions that work for the community so that we can get stuff built.
So to the project that you're currently doing in Utah with the closed loop, which is kind of somewhat new, correct? Was that wrong?
I wish that was ours, but it's not ours.
Oh, I thought it was yours. I misunderstood.
It's an example of
Okay,
what we're
I
looking at
misunderstood that. Okay. So is that something you guys might still be considering?
Yeah, no,
in our
100%.
area?
Those are the types of technologies we're looking at. I think our ask for these different industry partners is to come. We say, table stakes is water. We know that there's not a whole lot of water to go around. So bring us technologies that can work with minimal additional water requirements. And then we get more deeper into the process, and we talk about the specific concerns about, how can you locate, away from certain, either ecological or community type resources. Are there, there's a lot of layers that we peel back in thinking through the types of development partners we want to work with.
Okay.
And it's mutually beneficial. These development partners don't want to do a project that's going to get a lot of opposition and spend a lot of money on exploring. So we're trying to figure out a way to kind of work together through public-private partnership.
Thank you.
Yeah.
Is there a difference between, can you explain the difference between Clean Start and Evergreen?
Yeah, so Clean Start is our default service. That's what everyone gets if they don't make another choice. And that's the service that we try to keep as competitive as possible on price with PG&E and savings when we can. Evergreen's the premium optional service that people have to call us or log onto our website to get. And that's the one that has about a $13 per month extra charge that is 100% local and 100% renewable every hour of the year. So Clean Start is not 100% local. It's from around the western U.S., mostly California, but some hydropower comes from as far away as like Washington State. It's really competing for low emissions and low cost. And Evergreen is local. So that's the two options.
And you usually try to stay below, because I'm noticing on one of the rate comparisons, it says like the generation rate for 2025 is 17.299 cents. Clean Start is 11138. So you usually try to stay below that. If the rate goes up like next year for 2026 residential electric, rate increase or comparison, how do you factor that in?
We're really looking at the total bill, because that's if customers, like if we cut rates 10% for generation, but customers' bill go up 10% because of PG&E fees or something else, we don't spend a lot of time bragging about that because even though we did something good, customers are hurting. And so we're really trying to look at the total bill. And what that means is that we're trying to smooth out the total bill for a customer and have it be lower whenever we can. So we're using our generation costs as the only lever we have. The reason that's limited is generation is only about 30% of the total bill. About 70% of the bill is PG&E still. So they're still doing the lion's share of the work. And so if we, like I mentioned, saving 7% on bills cost about $50 million this year. So it's a big undertaking to have cash savings like that.
Then I noticed the electric power generation mix, who you purchase from, that's really what, I see that you purchase from large hydroelectric areas, and then I noticed that you said you were building windmills, basically, I seen on there. Your company builds that? Or has a
not directly. We find so by signing a 20-year purchase agreement, our financing becomes used to construct the project, and then because of tax credits and because we were young, right? We had to start with a small team without all the engineers and the contractors and all the resources. We're contracting that out, right? So that's a third-party private company that goes out and builds the large solar projects, the large wind projects, our recent battery project, things like that, and then from existing resources too. So Calpine, those are existing resources that we're buying from them today, as well as hydro, and then it's the next decade that we're looking to stand up our ability to construct ourselves and operate ourselves, and that'll be a stepwise process. We won't get there in 3 years. We'll be doing small solar projects first with batteries and then adding on and growing and getting more sophisticated over time.
I know it would be a long shot, but there's a hydroelectric project in our...
That's what my pen was up for.
Oh, now I think I know what you're talking about.
Good minds.
That might be a difficult conversation.
That's why I just said it like that. Supervisor Pye, did you have yours?
Well, I did for the same comment you just made.
Go ahead, Supervisor Pyska.
So I do want to give my perspective on the geothermal expansion. I think it's something we need to pursue. I'm very interested in it. As Supervisor Owen said, resistance to that development many decades ago has set us back and cost us a lot. And we need to make sure that we're not continuing that trajectory. We need to look at expanding what we have here. And I know that map looks scary to a lot of people because it covers a lot of communities. But as Ryan mentioned, we're not going to be developing something where people live. And we're not going to be and a developer doesn't want to develop in a place where it's going to be contentious. I've lived with geothermal most of my life. I'm less than a half a mile from facilities right now. So there are issues, but over the decades, there's been a tremendous amount of improvements on air quality, water quality, monitoring, seismic monitoring, all of the things. So it really can be done. And just that map shows potential. It doesn't dictate where projects are going to go. That is always going to be up to us. Our planning department, our planning commission, and our board. So that, I can't speak for the rest of the board members, but that's where I am right now. We need to be able to look at expanding, not just geothermal, but also other possibilities, including biomass, because I've spent the last year working on a biomass feasibility analysis for our county, and we do have a feedstock that can support some amount of production. And so we need to be able to fold that into our portfolio as well. And we've got another person in the room here who's been working on a project. So there are a lot of possibilities in our county, and we need to be open to expanding them for the benefit of our residents.
I second that.
Do you have a Vice Chair?
Well, I guess I'll just comment where I'm at right now. I think it's definitely something that we need to pursue. I definitely want to vet out all the risks and look at that closely, but I don't see a downside to continuing on with this process to look at offering this option to our community. I think it's a good idea. As far as the geozone goes, I don't have a concern about, I do have concerns about the projects down the road, that they need to be vetted and looked at, which we have environmental review process. We have all these processes that they have to go through to get vetted, which includes feedback from our community. But as far as, I think, I'm good with entering the geozone, knowing that doesn't automatically mean that we're going to have all these projects standing up down the road. They still have to be vetted and go through all the processes. So, I'm confident that we have the process in place to, if one does go in, to make sure that that was the right decision. But I'm good with being in that zone.
All right. Supervisor Sabatier?
I'd like to ask maybe Mr. Rothstein or Mr. Rickelman, what is our process? So in August, your board gets together and makes a formal offer, and then it comes back to us, and what's our process? I mean, we're talking about vetting the risks, and I can go home and think about it, but like, what's the actual process of truly vetting the risks and truly coming back with guidelines, criteria, or just more information for us to make a decision? Just kind of curious as to what our steps are.
So internally, excuse me, as described on the slides, our due diligence steps would be over the period of the next, few months, and having those, council to council conversations so that we can have, the clearest possible picture to present to your board. An offer of service being extended by the board would, by the Board of Sonoma Clean Power, would then trigger that, public process thereafter that was also described there. And we have heard from Sonoma Clean Power that the timeline for Lake County joining is not necessarily their primary concern. Obviously, if the timeline is pushed further out, that would introduce a greater uncertainty in terms of what costs would look like, for example. But Sonoma Clean Power is representing to your board, though, today that if that's the will and the direction of your board, that undertaking those steps of going to the town halls and things like that can be possible. But we certainly would be looking at the risks and making sure that council to council conversation, particularly as Supervisor Pyska raised, would occur.
I would just add for clarification with the state CPUC process, if we were to wrap up the process of Sonoma Clean Power sending the formal invitation and the county accepting by the end of the year, there would be that gap year. But if this would go into 2026, then potential service would start in 2028.
Go ahead.
When they come forward and then you open it up, it'd be there during that time, after you present it to our board to consider it, would it be at that time that you would attend the town hall meetings around the county before we make a decision? Because again, I feel that there needs to be public input.
So that option is yours, really, and I'm happy to follow your lead. The history of how agencies have made this decision in the past, for reference, is that because customers don't have a choice today, local governments, after some vetting process, and clearly that's important, made decisions to create that option for customers on the contingency that we had to be out in the community both during and after that decision in a significant manner to make sure people understood their options. It wasn't as much take a year to wait to make the option available. That's not the history. So this would be a new path for us. Mm-hmm. I'm open to doing that if that's the will of the board, and we'll follow your lead.
Thank you.
I'm going to open it up to public comment and then come back to the board after.
Good afternoon, Tom Lasik. I put in a comment as a neutral party on the e-comments because I truly am on the fence on this. I'm a huge fan of CCAs in general. I think it's the right move for California. I'm a huge fan of geothermal and other renewable sources of energy. I've had clients that were power plant industries on the East Coast for a couple of years, so I'm very familiar with the energy industry and I follow it. But I am on the fence because when you first brought this up, when SCP first brought this up, it was made clear that the question was including the community as essentially customers, as ratepayers for Sonoma Clean Power, and the conversation on geozone would be kept separate. I've read the feasibility study. I've listened to the SCP board presentation from last month. And my concern is that in order to have our community enjoy the benefits of SCP, there needs to be or could be a precondition for the geozones. I'm not against geozones. And by the way, if I may indulge the presenter to bring up the slide on the expansion of geothermal, just as an example, we're not sure what we're actually talking about yet. If you go to the website for SCP, they talk about plants of the size of a house and are very unobtrusive and could most certainly probably fit just about anywhere in the county. But there are other ones, like the ones that were presented a couple months ago, that are quite large and are multiple ones. I think it was in Oklahoma, and it kind of looks like South Texas, where I used to live. This one here, if you notice, there's some really, really tiny people there. That's how big this plant is. Mm-hmm. So we don't really know how big this is going to get. We don't know if it's open loop. We don't know if it's closed loop. We don't know what technology. And I think those are all fair points and questions that the community would ask. I also think that because a large part of our county is a candidate for geothermal, which is not necessarily a bad thing, it does put it closer to a lot of relatively densely populated areas in our community, potentially. But we don't know the answers to that. I personally feel that if geozones was not part of the conversation for this round, you would get a very large support from the community. You would probably easily get over 90%. But as soon as you start talking about putting something like this or not being able to answer the questions eloquently, you're going to run into more difficulties and resistance. So I would encourage, and I'll close real quickly, to please keep it separate, as was mentioned at the last meeting, and lock in the community on getting lower rates for themselves, and then have the conversation after you've built the goodwill and trust of the community, to have the discussion on geozones, because I do believe that is a viable option, but I don't like the way it's been navigated here. Thank you.
Thank you.
Thanks. Come on up, sir.
Bill Wilson. I have a question. It'll probably only take a half hour. When you talked about PG&E delaying the financial credit, to be sure that is not what we are being paid for our production of solar panel back to PG&E. That won't be that. And the second thing, when you talk about preserving your reserves, electricity can't be stored unless it's in a battery. What are your reserves? Or is that just plants that aren't online right now? Thank you.
Okay, yes, go ahead, sir.
So when I speak of reserves, I'm speaking of financial reserves. So this is cash funds used to help levelize rates and protect customers from sudden rate increases.
His other question about the delayed the PCIA credit that does not related to behind the meter solar credits at all. That's separate.
Any other public comment?
Hello, good afternoon, Lake County Board of Supervisors and Sonoma Clean Power. My name is Amanda Martin. I'm the CEO of the Lake County Chamber of Commerce. So I just wanted to echo some of the supervisor's concerns here about public input is very necessary, it seems, for this, with this being a permanent decision for the county where all of our citizens and businesses are opted in. So I just wanted to extend the Lake County Chamber of Commerce's interests in putting together town halls in partnership with you as the supervisors to spread that word throughout Lake County. Also, just to note that public outreach in Lake County is kind of unique. You know, we have a lake in the middle with 100 miles of shoreline, so getting the word out does take some unique efforts here. Then I also just wanted to ask you about how can this benefit our small businesses? Because what we're hearing from our small businesses is that they're being pinched by their utility rates on both sides. You know, their PG&E rates are literally putting some out of business, and then it's pinching them from the angle of their customers are not coming in as much because they're seeing the increases at home. So if you could just speak to how this would benefit small businesses, and if you could speak more to your advocacy work as well.
Is that you have more?
Nope, that was the full question. Thank you.
Thank you for calling out small businesses. Small businesses have historically been some of the hardest to connect with customers across the electric sector since electricity was invented. They're busy. Because they're small, they use relatively modest amounts of power, so large utilities tend to ignore them because until they're forced to do things. And we share the same challenges, but we have recently made some efforts to benefit small businesses besides our rate protection measures that we try to provide to everyone. And what we're experimenting with right now is going in to help small businesses figure out how to trim their bill in customized ways. I don't want to brag that we can do this for everybody right now. It's very high effort. It requires highly trained folks, usually 2 at a time, to go to a business and look at their refrigeration, look at their ovens, if they're a bakery, look at their, all the things in their business and learn how they can trim their bill. But that's the kind of thing I want to scale. That's the kind of thing that matters. When we put insulation in front of the ovens at a bakery, they saved $47,000 to avoid an air conditioning system. And that absolutely made the difference for this really small bakery. So it's things like that we want to do more of, but it won't happen overnight. That's the kind of thing that takes a large team of people and time. So I want to be honest.
All right. Any other public comment on Zoom? All right. Bring it back to the closed public comment and bring it back to the board. I think it's direction. What do we have? Go ahead, Supervisor Sabate.
I don't want to misspeak, but I think right now we're just waiting on, there's shared interest, but until there's an offer, I don't know what direction to offer.
Okay.
Well, the risk analysis.
Upon receiving the offer.
Well, I think we can start the risk analysis now.
Okay.
We're happy to provide our attorney to help in any manner and our technical team as well.
Yep, thank you.
At what point would we start bringing in the public? Would it be now or after the risk, when you guys come back? Would it be during that time? I'm just curious so we could.
So I'll take staff's lead as well. So I'm looking to staff, but we're happy to continue to get the word out for all the times we're here. So we're here next week at Lakeport and Clear Lake. And we have helped create a flyer that all 3 entities have been sending out to community events, to Travel Nations, to other folks to try and encourage people to show up. It is hard to get people to show up when the decision hasn't been made yet. That is a challenge. And so I'll be honest, we have provided community events where nobody comes. And so it's better for us to go to somebody else's event than to.
That's what I was getting at, yeah. And Amanda had mentioned that she'd be glad to help participate in setting those up. I wasn't sure if any of my colleagues are interested in them showing up at your town halls or anything?
Always.
Always? Okay. So we can go ahead and look at trying to get you scheduled to some of these, and Amanda, maybe you can help with that. So,
Absolutely. Thank you.
thank you.
Well, I was just going to follow up that, like, I've been mentioning it everywhere I go at multiple meetings, and, you know, the county and the cities jointly put out a statement last week, which has got, you know, some attention. So I think, you know, while there definitely needs to be ongoing outreach, I think the word is starting to get out.
Yeah, I think you were.
Oh, I mean, we have scheduled monthly town halls. You could have all of us in a month, and they all have virtual capacity.
I think it'd be key to hit those questions about opt-outs, and I think for us, you know, because this is more of our deal, we're worrying about making an agreement for 20 to 25 years, something change, we don't know the future, things like that. We want to be able to weigh those options as well. So I don't want to burden a future body with 40 million to 100 million, and so I just want to make sure we get. Go ahead. Yeah.
If I may, should we contact your offices individually to set up town hall meetings?
Mm-hmm.
Okay. All right. And I'll ask staff for a little help with that. But thank you.
Yeah,
I appreciate it.
There's,
Chief of Staff.
there's 7 of those town halls, and there's sometimes a different supervisor on each one.
And for me, I don't want to make a decision and have it costing our community more, you know, than what it would. And then we've got egg on our face because we, in good faith, thought that we were making a good decision and then have it backfire on us. And so.
All right. If there's not anything else, no other direction, is there anything else you want to close with, or are we? No? No? Okay. All right. Well, thank you for that presentation. We'll look forward to further meetings and discussions about this, and hopefully we can get the information out that people are concerned about. Thanks. With that, I know that's how do we go about this? And I think I need all of you
Chair?
to give input. Yes.
Would it be possible to take a 30-minute lunch rather than an hour?
How does everyone feel about that? 45? 45. 40. Meet you halfway, 45 minutes. So we're looking at 1:30.
Just trying to help get back.
You know, I should have stopped Scott. Wait. Yeah.
So you have 6.8, which is at 10:45.
Mhm.
That's the road commissioner.
Mhm.
So if we're coming back at 1:30, we can make that 1:35.
Mhm.
And then the next one is the cannabis,
Mhm.
which is problematic because you have a 2:00 grievance closed session.
Mhm. Okay, so you're asking me what we should do?
Well, I'm asking you, should we make it for 3?
Okay.
These are the two you need.
All right, so real briefly, we're going to go over what's going to take place when we return. Our 6.8 is our 10:45. We're moving it to 1:35, which is our road commission. Our 6.9 cannabis item is going to be moved till 3 p.m., and our 6.10 will be continued at a later date. And with that, we'll still be back at 1:30.